Right, tender apology because of wrong conception of law, and on the basis I have checked it up. And I take the 2009 rule. It is there. Your Lordship passed the judgment in respect of 1981 Malad scheme in terms of. Now I have checked it up. If your Lordship takes 43 of that,
this is volume.
that volume 1.
My lord, on the last occasion I have marked it. We flip. Pink one. Read the page number. Page number.
Page number is 208, and prior to that,
yes,
page 188. Kindly take first. We are confused by the word itself. This is our misconception of page 188 of that particular book.
188, yes.
Head note kindly sees West Bengal primary education employees. We are confused by the word employees. We thought that is the employee of the council itself.
Okay.
So if your Lordship kindly take right hand side 189, that it is applicable in respect of exercise of power conferred under subsection 1 of 106 of read with clause Q of subsection 1 of section 60 of the Primary Education Act 1973. Now, in order to scheme notification subject, my lord got the preamble, preliminary, and right hand side that it is 3F. Employees. Employees means an approved teaching and non-teaching staff of government or government aided sponsored training institution or primary teachers. The approved employee of district primary school council and board. Now, approved teaching and non-teaching staff of sponsored free, we are covered by column 3. The teachers of a free basic pre-primary nursery such and such under the 1963 Primary Act, and teaching and non-teaching staff of a school over from municipality and other primary schools under the state of Kojbeh such and such. Now, this is the amendment overriding effect of 1981 pensionary benefit. Your Lordship quoted that 26. Now, kindly take page 208.
208.
43. The provision of West Bengal recognized non-government educational institution employees death cum return benefit scheme as applicable to the teacher of primary school, along with the notification, memorandum and orders published, earlier notification, eligibility, application, administrability of the benefit under the above recognized such and such, 81 shall be deemed to have been repealed, and so far they are repugnant by matter of rules. So therefore, 1981 rules is repealed by virtue of this. When your Lordship recall that order itself, taking into provision of repealing statute or scheme.
And also 29.
29.
There is a note.
Yes.
26 in 1981, 26 is the note.
Note. Yes, that is there. Now, my entertainment could have been there if my predecessor or husband expire prior to this rules. Yes. Then this is not applicable then, prospective.
This matter is appearing under the heading.
No, let it be today itself. Kindly recall that and dismiss the petition.
The impugn order passed without non-speaking order.
Oh, ota thak. Emni to pabo na to. If I am not entitled, question of relegating the matter does not arise. Why? না কিছুই ডিসকাস করি ও দরকার নেই তোমার বলেছে একটা যে ওই ওয়াইফ টার্মস অফ দা ফ্যামিলি হ্যাঁ এটা 29 এ কভার করে যাচ্ছে ওখানে দেখে নিচ্ছি ওয়াইফ অনলি ওয়াইফ পার্সোনাল ল না দরকার নেই মানে recall it and dismiss it. Futile exercise for sending the matter, although this is a cryptic order, it could have been sent, but if the regent order comes, then 29 will be improper. Rule 29.
Okay. This matter is appearing under the heading to be
Sorry
mentioned.
for our inconvenience and misunderstanding of
Correct.
the law.
We correct the position of law.
That is
This should not be taken advantage by as a way of precedent.
correct.
Even if the state does not go in appeal, this remains.
Remains and
So I thought it's better to recall for future purpose.
to settle the
Yes.
law itself.
Yes, to be mentioned.
Don't take us,
No, no.
Miss my lord, our misconception of law.
By
They are good.
order dated 21st July 2026,
দরকার নেই, এটা
the
পারবে
writ
না, পারবে না।
petition was disposed of, directing, setting aside the order of District Inspector of Schools P South 24 Parganas dated 17th April 2025 and directing as follows. Para 10 set out of that order. Upon mentioning by the learned advocate for the petitioners, the matter has been listed today for clarification, further clarification. Mr. Bishuru Biswas, learned advocate appearing for the petitioner, in his usual fairness, submits that the order dated 21st July 2026 was passed basing on the provisions of Death Cum Retirement Benefit Scheme 1981. However, in case of the petitioner, the DCRB rules of 2009 applies. As per the DCRB rules 2009, the petitioner, being the second wife, is not entitled to pension. Rule 43 clearly provides that the benefits under the DCRB 1981 shall be deemed to have been repealed insofar as they are repugnant to the matters covered by the rules. It seeks for appropriate orders for recalling the order dated 21st July 2026.
May I?
Learned advocate.
Page, quoting the rule 29 note. Can you mention this?
Okay.
I am not
He
entitled.
also indicates that as per Rule 29 of Rules 2009, the petitioner is
No.
not entitled to family pension being the second wife, since
Personal law.
bigamy is barred by statute and personal law of the petitioner.
Grateful.
Mr. Brijendra Pratap Singh, learned advocate, also indicates that Rules 2009 applies in case of the petitioner.
One more submission. Now, it is a settled law. If the order is passed contrary to the statute or omission to the statute, court has inherent power to recall. Well, can you add this? Your lordship, otherwise, functus officio come.
Biswas further indicates that since the order passed is
repeal that
passed on the basis of a repeal provision, the court has inherent power to recall such order in order to avoid future anomaly.
I'm so grateful to others.
Leads the matter. The order, admittedly, the order dated 21st July 2026, directing the authorities to grant family pension in favor of the petitioner being the second wife, has been passed on the basis of the note of Rule 26 of DCRB Scheme 1981. It has been rightly indicated by Mr. Biswas, learned advocate for the petitioner, that rules of DCRB 1981 does not apply in case of the petitioner. It is relevant to, at this juncture, it is relevant to reproduce rules 29 and 43 of the rules 2009. Upon set out korben, upon bare reading of the aforesaid rules, particularly note note to Rule 29, which provides as where an employee survived by more than one wife, the family pension shall be paid to them in equal share. This shall not be applicable in cases where bigamy is barred by statutes and personal law. Therefore, the petitioners, by petitioner being the second wife, is barred by statute and personal law by which the petitioner is guided. In view of the above, the order dated 21st July 2026 is recalled. The writ petition being WPA number 21814 of 2025 stands dismissed. Any benefit has been extended?
No. I have not communicated till.
Oh.
Anything has not.
It is informed by the learned advocates that no such consequential steps in respect of order dated 21st July 2026 have been initiated by the respondent authorities. In view of the above, nothing remains to be decided. Dismissed. Okay, thank you.
Again, I am tendering apology because of that
Right.
particular word. We are misled by
Okay.
this. It is our wrong understanding.
Thank you, Mr. Vishwan.
I'm so grateful to your lordship.
Next. Bolo.
My lord, item number 4, my lord, I was to make submission that 22 wrong question matter.
You are for the board.
My only anxiety is suddenly, my lord, one day they'll start recruitment and then the rights of these petitioners will become illusory. So, my lord, I'm
Okay.
requesting my learned friends, my lord, to
I am
The
ready.
date থেকে রাখো তো August
to enable your lordship, my lord. to
August
decide the
দেখো
matter.
তারপর how many? Only Mr. Dasgupta is left to make submissions.
For the petitioners,
My lord, I was representing the petitioners in
Five. দেখো একটু দাও
My lord, Mr. Shaptangshu Basu, my lord, led arguments. I came second, my learned friend
yes.
submitted. Now, my lord, we'll complete it.
my lord, I owe only my lord one duty to your lordship. My lord wanted my lord a chart, my lord indicating my lord the wrong answers and with the right
আমি
answers.
করে দিয়েছি আমরা।
This is
স্যার আমাকে একটা কপি দিন
My lord, what we my lord,
Yes. Yes.
what we'll do, my lord, I'll sit with my learned friend. Kindly take his chart also. I have also given question-wise chart. And all petitioners, my lord, before conclusion, will give a joint chart.
Comprehensive chart, yes.
Joint chart, so that only that, my lord, your lordship can see while deciding the matter.
Yes.
It will be easier.
Yes, of course.
দেখো who is appearing in item numbers 4,
my lord, item number 4 and 8,
Yes.
I am appearing.
5, 6.
5, 6.
I'm for the petitioner, my lord, for item number 5 and 6, led by
Five.
Ms. Gopa Bishwas.
5, 6, 7.
My lord, 5, 6, and 7, led by Ms. Gopa Bishwas, my lord.
15,
And 15 and 16.
16.
Yes, my lord.
All these matters I am releasing on personal ground. তাহলে আপনি এই নাম্বারটা দেবেন না when are you going to Mr. Dasgupta you will argue
My lord,
end of আপনি দেখুন অগস্ট এন্ডের ডেট বলুন তারপর
my lord, any day subject to your lordship's consent.
তারপর 27 থেকে কটার সময় সেকেন্ড হবে 27 3:30
My
আচ্ছা take down on the joint prayer of the parties list this matter on 27 August 2026 at 3:30. On my personal ground, the item numbers 5, 6, 7, 15 and 16 are released from the list of this page. Release the other writ petitions excepting the item number such and such.
My lord, I have my lord, in item number 10, my lord, I have my lord submitted my lord the chart. If my lord is kindly take
Chart. chart submitted by Mr. Banerjee, learned advocate for the petitioner in item numbers.
Take,
Yeah,
my lord.
three read petitions are there
Yes. My lord, in item number 10,
in
under my lord,
WP
yes.
28297 of 2025
Grateful.
is taken on record.
I'm so grateful. And my lord, instead of 3:30, my lord, may it be at 3:15, so that my lord,
Yes,
in
ma'am.
case even if my lord there is a resolution,
We
my
can
lord, the
continue.
argument starts.
Yes.
Starts.
In fact, my learned friend was saying he'll take half an hour. If we can request the board also to come on that date and finish it, if possible.
We will conclude on that day. You
Yes,
are the
my
last person left.
Last person.
My lord, only thing I am not challenging the questions. I am only saying that it has been accepted, the mistake of it.
Okay. বলো 3:15 দাও
So grateful.
ও
my lord.
বলছে
So
যদি ওরা
grateful.
কন্টিনিউ করতে চায় তাহলে করে দিতে পারবে ওরা ফ্রাইডে
সাড়ে তিনটে হবে না।
Now, we'll continue until
First,
4:30.
It's vulnerable 3:30, my lord.
3:15.
I'm so
3:15.
grateful.
yes, then we'll continue after 3:30.
Yes.
Okay.
On
Deep-
that day.
If there is a resolution.
Even if they.
In the event there is resolution.
Yes.
Fridays,
No, no,
Right, this
Thursday.
is Thursday.
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 Fridays now, my lord, we are fixing arbitrations at 3:30.
I cannot comment on it.
This was on a lighter note, but it is true.
Thank you.
Grateful.
Thank you.
দাদা
Lordship, item 20 to 27, Lordship, are analogous.
There's a
matters.
direction to file a reply to the restoration. We have affirmed. And Lordship, kindly restore and please the hearing.
You have heard?
Lordship, for the Paschim Bengal Samagra Shikha mission, Lordship.
Yes.
Lordship, for my Honorable Justice Rai Mukherjee was leading me, Your Lordship. Lordship sees the last order. 5th August, last order.
No.
And after that,
who will
TVS
appear?
Lordship, no formal appointment
Who
has
will
been
argue?
made, Your Lordship.
Who will argue?
Lordship, no formal appointment has been made, so I'm praying for 2 weeks' time so that the Paschim Bengal Samagra Shikha can. I've given an opposition to their application.
And we have filed a
And
reply.
I filed a reply just today, Your
Yes.
Lordship. I haven't been.
Item number 20 you give?
Lordship, 22, 27, all.
20 you give? Affidavit in reply filed by the petitioner applicant is taken on record.
Lordship, we can sub a
And Lordship,
copy also.
similar matter, Lordship,
Copy served.
appearing under the
Give a
heading.
copy. Give a copy. Copy served.
Lordship, a similar matter
Advocate
fixed under
wants
the heading
number-
hearing.
Yes.
Bunch of matter appearing today under the heading hearing, Lordship. Can you respect?
Hearing.
There is only 170 days delay, 180 days delay,
Lordship,
240,
this
284
matter
days
also has a
delay.
delay. We
only
filed an
3,000
opposition against their condemnation of delay application. They've just filed the reply for that today, Your Lordship.
Only
Therefore, we
for
pray.
restoration,
There are delays of 3,000 days also, Your Lordship. We're praying for.
Here, Lordship passed a
to be-
similar order to condone those delay, Lordship.
What
You
is his
kindly
name?
see your
Joyjeev Medhi, Your Lordship. I've appeared on the last.
Joyjit.
Joyjeev.
Joyjit Medhi, learned advocate for EBSSM, respondent number 2, submits that the learned advocate, conducting advocate, has not yet been appointed in place of Mr. Mukherjee. He seeks accommodation. Erstwhile learned advocate call. When will this be made?
Your Lordship, 2 weeks' time I'm praying for, Your Lordship. I need it after 2 weeks would be preferable, Your Lordship.
What is the item number of the hearing list?
115, Lordship.
Onwards.
Onwards, Lordship. Mr.
1152,
1152,
125,
125, Lordship.
125, I suppose.
There's a bunch of 30 matters, Lordship.
Lordship, if I see from the list, the no cans are.
No,
Uh,
these all
pending
are
in those
hearing
matters.
matters.
No,
These
the
all are hearing
matters are
Lordship.
not
Cards,
ending because that is the reason why it has been placed under for hearing.
Lordship. Lordship,
Absolutely.
can you restore matter, Lordship? The issue has been decided before the Supreme Court, Lordship. Substantial justice, your lordship.
Only for 15 days for
Correct.
application to hearing. Two weeks for date. Din. Next, 21.
15 days time has been granted.
21, you give the reply.
Dada.
Same all. এবার reply থাকবে না ওটা বাদ দেন। 22.
কোথায় না? আরে সবই তো মানি না। তুমি পড়বে, লিখতে তুমি পড়বে।
23.
সবখানে দিয়ে দিচ্ছি।
একটু দেখি রেট অফটা। 24টা কত বলে?
সন্তোষ কুমার কানু।
988.
6988.
6988 2016. 6988 of 2016 is the writ petition number. Item 24.
6988.
পরে মিলিয়ে নিও, অসুবিধা নেই। ওটাই সবার লাস্টে আছে।
24.
এটা চেঞ্জ করো। তুমি বাক্সটা চেঞ্জ করে দাও। এই আমরা তো এখন 25.
ওটা দেখলেই হবে। বুঝলি লাইটা?
দিলীপ সিং সাহা।
25. দেখি দেখি দেখি।
সেই লিস্টে কস্টাইটের জন্য বাদ দিয়ে না, ফ্রেশ করতে ওটা বলে দিচ্ছি একবার। আর কস্টাইটের
Up to 27.
ফ্রেশ করে
Up to 27. 20 to 27.
Lordship, can you remember one thing, Lordship? The one similar matter, one matter, Your Lordship, there is some mismatch to cost title. Your Lordship, grant me to liberty to file a fresh. And that I have filed. And Your Lordship, I have mentioned, Your Lordship, direct me to when the matter will be called down, you will remember me.
So the matter
Just
is not in the
inform-
list, Lordship. I'm not informed which matter my learned friend is talking about. It's not in the list, Your Lordship, I believe.
Can you see this order?
দেখি।
দাদা, এটা সবকে চাইছি। আরে চাইছি না। ভুলে যাবো কেন? এত দশটার মধ্যে ভুলে যাবে তুমি কি করে?
নাম্বার কোন লিস্টে আছে
এই
নাকি?
তো না, লিস্টে নেই। দশটার পর যখন ধরবে তখন ইনফর্ম করি।
ধরবে না।
আচ্ছা, file the application.
Lordship, there is some mismatch, therefore Your Lordship grant me liberty to file fresh. Can 3 and can 4.
Can 3 or 4 take a list করে দেবেন তো?
To be mentioned, so same direction maybe.
Lordship, I think it would benefit everyone since if the
Similar
matter is kept
matter,
after
same.
2 weeks, because there's no counsel. Even I'm facing a difficulty. I'm
Okay,
getting
then
all the
next
briefs from
tomorrow
Mr.
to be
Ramkotti's
mentioned.
office, and I'm not being formally engaged myself also. Therefore, someone's appointment is definitely required to go ahead with these applications. So it'll benefit everyone if everything is kept after 2 weeks, Your Lordship.
Makes it tomorrow to be mentioned, pass the similar order and fixed on that day, Lordship. Same
Mm.
order, as per your Lordship,
And they will be filing an opposition to that application.
if they want.
Will it come up tomorrow?
Tomorrow to be mentioned.
I'll be praying for time only then in that.
No, the direction has to be given. If you intend to file in opposition, so in that
Fine. Great.
meantime you can file that.
Great.
Opposing you can take
Grateful,
3-4 weeks time. That
এটা কালকে তুই মেনশন এ নিয়ে এসো।
number লিখে দিচ্ছি।
After 15 weeks, 15 days, Your Lordship, 7th September. All of them, 20 to 27. Grateful.
Okay, pardon, madam.
My lord, we are not being served. We are not being served.
Your Lordship, we are there for item number 28. We are for the alleged container. My junior is there. We have not received a copy of the content application. This can be served so that we can take necessary steps in this regard, Your Lordship. Just being appointed in this matter recently.
Post, I mean, that will serve contempt application. Who is for the applicant? None appears on behalf of the applicant petitioner.
Yes, Lordship.
A so and so learned advocate
Yes, Lordship.
appearing through virtual mode.
Lordship.
The copy of the contempt application has not yet been served.
Right, Lordship.
For ends of justice, the matter is adjourned. Is this next week? Now, the applicant is not appearing, so I'm placing
Yes.
it the coming week. It will be listed. If they appear, fine. Otherwise, we'll pass on. Next week.
Lordship. Lordship.
Okay.
Grateful.
Now 29 2 p.m.
30, my lord, I am for the petitioner, my lord. The affidavit of service filed, my lord, showing the, my lord, compliance of your lordship's order. Copy has been sent to the concerned alleged contempt.
Complied?
My lord. No, not yet complied with, but the copy has been sent.
Oh.
Duly received.
Who is the alleged contemptor?
Page 12 of the order portion, my lord. Paragraph 7, start it.
Incomplete. This affidavit of service, the track consignment, a report is incomplete. Where
Item
is the
delivered.
track consignment? report?
Item delivered, my lord.
Where is that? Where is the track consignment?
Right side. Item delivered আছে।
File a fresh affidavit of service.
Item delivered page.
Item delivered, pin code given. Item delivered to the addressee that is not appearing. So get the further track consignment report and file a fresh affidavit of service.
Delivered বলছে তো। রায়গঞ্জ ডেলিভারি সেন্টার।
Affidavit of service filed on behalf of the petitioner is taken on record. Well, you file, you serve afresh or you file a fresh affidavit of service?
My lord,
You will serve afresh.
my lord.
Affidavit of service filed on behalf of the petitioner is taken on record. It is found that service has not been affected upon the alleged contemners. Then the advocate for the petitioner is directed to serve afresh upon the alleged contempt and file affidavit of service on the returnable date. This is matter after 3 weeks. 3 weeks. For.
দিয়ে দিছি না? আবার একটা কপি স্যার।
In this matter, that led by Mr. Majumdar, learned additional advocate general, is in some personal difficulty. Is not available today, and additionally, similar matter is
And I have filed an application that would be taken up.
My lord,
For addition of.
my addition of party application.
স্যার কবে থাকবে?
Can 2 is not appearing today.
কবে করতে চাইছেন এটা?
any day.
Can 1, can 2 কোথায় এটা?
That would do, that would.
Yours is can 2.
Yes.
Who is can 1?
And I am for can.
Can 1.
This is for the addition of party as respondent, but your lordship kindly. I think they have no objection.
Copy you have given.
I have given all this. Everybody. And the other one.
Kitchen.
ও ওদেরকে দেন রেসপন্ডেন্ট কে দেওয়া
Also want to flag one thing.
রেসপন্ডেন্ট কে দেন
Similar matter is pending before court 1, which is being heard, which is likely to be listed on 16th of September.
Okay. 15th.
16th, 1/6.
Okay. Cancel, withdraw.
And application be allowed later.
Copy to him. Give a copy to the learned advocate for the state.
Yes, sir.
I
have sharp copy.
Who will argue on behalf of the state? You are carrying the copy of the public interest litigation filed before the.
I'm not carrying the copy, my lord. I have the order, last order passed in the matter, which fixes. Please.
Then this has to be released from this bench.
But
Then if they add as a party, then
Madam,
they add
I'm for
also.
the petitioner. If the matter is released, I will be losing one forum, single bench.
The matter is being taken up by the Honorable Chief Justice, Acting Chief Justice. Then
Madam, make it another day. I have not gone through the PIL matter. Madam.
what is the challenge in the PIL? The same notification or the notification of the
It's my instruction, my
Home
lordship.
Ministry?
The same notification has been challenged.
No, my lord, I may, oh, sorry. No, আমি বলছি, my lord, the same notification is in, I'm appearing in the matter led by senior advocate Razi Majumdar in this Said Imtiaz Ali matter, which
Where
my
is Mr.
lord has an order
Majumdar?
of. Order which, yes,
He is appearing in that matter.
yes, before court one in with Mr. Razi Majumdar, the same notification regarding order notification which asks for this song to be played in the madrasas is in challenge there, my lord. So, my lord, it is being heard. Affidavit in opposition is to be filed in that matter.
Okay, you do
So
one thing, you produce the copy of that. I just need to go through the prayers and find out whether this prayer
Fair
is
enough, my
similar
lord.
to that.
Can a short passover be given, my lord? We can produce it.
Produce that.
We can do it. I have it in my tab.
Let the application be allowed.
No, how can that be allowed? The application along with the writ petition will be released to be taken up by the courtroom number 1.
কি বলছে একে কোথায় হবে ও যেহেতু এখানে
I can get the copy, hard copy also, but I have it in my.
Ask Mr. Rajdi Majumdar to appear. I'm fixing it in the coming week. To come with that copy of that, we'll see what is the prayer and all. Accommodation is sought for on behalf of Mr. Rajdeep Majumdar, learned additional advocate general. Please this matter on next Wednesday the Rapan.
next point.
But I am appearing in can 2, my lord. Addition of
Can you just
Next,
ensure that the copies have been served upon
File.
next question is on top.
and also you find out whether the prayer which has been made in courtroom number 1, if
File.
it is similar, then there is no
File.
question of
I
keeping
see.
the
I
matter
see.
released. Next.
Okay.
Mr. Yes, let us first hear him.
Yes. ভাই তাড়াতাড়ি করো। Milord, Milord, have to stand in the way of the prayer for adjournment, because Milord, there is extreme urgency in the matter, and Milord, I am not asking for anything against the respondent number 8, Milord, whom Mr. Badi is representing. My lord, even need not look at the records. I just tell your lordship, Milord, the facts, and then if required, Milord, I'll take your lordship through the Milord documents. Milord, this is 4th round of litigation. Milord, the dispute is really between Milord, the petitioner in this petition, and the respondent number 8, Milord, whom Milord, Mr. Badi is representing. Milord, there was an interview long back for Milord appointment to the post of assistant headmaster in a madrasa. I was an aspirant. Respondent number 8 was also an aspirant. Both of us, Milord, put in our application. Milord, apart from us, 2, Milord, there were 3 more, Milord, applicants. Milord, the respondent number 8 was found ineligible to participate in the selection process because, Milord, he had opted B.Ed degree not through conventional mode, but through ODL, Milord, distant learning, Milord, system from Netaji Subhash Open University. Plus, Milord, number 2, Milord, he was not given permission to get, Milord, higher qualification, obtain higher degree. So on these 2 counts, Milord, all the authorities found him ineligible. Milord, challenging that first writ petition he filed. Milord, this honorable court and honorable coordinate bench was pleased to direct the authorities to, Milord, hear him and then take a decision. Milord, the hearing took place. Milord, again the same decision, Milord, prevailed. He filed second writ petition. He said that he was not harmed. Milord, the honorable court was gracious enough, directed the authorities to hear him. He was heard and order was passed. Milord, the order remained the same because he could not show any document to satisfy that, Milord, distance learning mode is, Milord, permissible. Milord, he produced one document, one notification, which was restricted to teachers for class 6, 5, 6, 7, and 8. So, Milord, does not apply to him, Milord, in a higher secondary school. Now, Milord, when the recruitment, after that, Milord, there is no, Milord, predicament, Milord, impediment for the authorities to continue with the, Milord, recruitment process, and I was selected as the assistant headmaster through the interview, being, Milord, the high scoring person. Now, while the approval was awaited, Milord, he challenged my appointment as the assistant headmaster in the 3rd round, which writ petition is pending before your lordship. There, Milord, reports were called for. Milord, reports were submitted by the authorities saying that he is not eligible. To those reports, to our knowledge, there is no exception till date, Milord, filed. Milord, the Honorable Court issued a direction saying that since I am in session over the matter, the Honorable Court is in session of the matter, let me not get the formal official approval till, Milord, the writ petition is disposed of, because my lord is, Milord, in seize of the matter and is, Milord, testing whether, Milord, I am eligible or not, whether he is eligible or not. In the meantime, Milord, I was, Milord, permitted to continue as a teacher in charge, because, Milord, as the assistant headmaster, I am to be the teacher in charge. So, Milord, approval was withheld pursuant to my lord's direction, and, Milord, I was performing as teacher in charge. 27 July, the matter was last taken up, the previous matter, 3rd matter, by your lordship only. My lord made it returnable on 11th of August. So, Milord, within the time gap of 27 July and 11th of August, Milord, the respondent number 5 today, who is, Milord, Sub-Inspector of Schools, appointed as the administrator because managing committee has got dissolved because of expiry of tenure. Milord, what he did, he, Milord, WhatsApped me 2 WhatsApp messages on 2 consecutive, not consecutive, Milord, in a gap of 2-3 days. He says, show me your approval through WhatsApp. Show me your approval that you have got an approval of your appointment as the assistant headmaster. Milord, I responded through communication in writing, annexed all the orders passed by my lord's court. Milord, informed him of the pendency of the writ petition and the order passed and the status. Did not satisfy him. Milord, he again, Milord, messaged me through WhatsApp and email, told me that I am giving you 3 days time. My lord will kindly remember, Milord, we are trying to trouble your lordship, Milord, coming again and again to mention a matter. Milord, I even, Milord, I am, Milord, really, Milord, sorry for that. Milord, took a chance, Milord, to mention the matter in the midst of 2 matters to one day. Milord, that was the urgency because, Milord, he told me through WhatsApp, I am giving you 3 days time. Give me approval or else consequences would follow. Milord, approval was withheld. I again told him that in writing. 11th August, Milord, the matter was made returnable. He could not wait. 10th August, which is now, Milord, subject matter of challenge, he said, since there is no approval, your appointment as assistant headmaster is cancelled. And now I am undertaking an exercise to elect or, Milord, select an teacher in charge.
But without appointing an assistant teacher, how a teacher in charge?
Milord, everything is in doldrums, and kindly see, Milord, the audacity.
Okay. Let me go.
Kindly, my lord, now have a look at the impugned communication first. My lord, page 414. My lord, this has become voluminous because you have annexed all, my lord, prior pleadings.
414.
Yes, my lord. In volume 3. And this is, my lord, shocking. Whereas, my lord, may I please this? This is, my lord, dated 10th of August by the sub-inspector who, my lord, because of, my lord, his post as a sub-inspector, is ex officio, my lord, administrator. Whereas the undersigned, my lord, the subject is selection of TIC.
Yes.
Whereas the undersigned, being the sub-inspector of schools, has been placed as the administrator of the madrasa by appropriate authority. And whereas, as per available office records, my lord, pausing here for a moment, this must include my lord's orders. As per available office records, it has come to the notice of the undersigned that the appointment of my client, the petitioner, to the post of assistant headmaster in the said madrasa has not been approved by the authority concerned till date, and accordingly, the concerned assistant teacher cannot hold the chair of TIC. My lord, he is sitting in appeal over my lord's order. Absolutely sitting in appeal over my lord's order. TIC of the school by designation of a HM post. And whereas, my lord, this is even more shocking. A mass petition dated 18 July 2006, signed by Shushmita Datto and others. My lord, I have reasons to believe these 22 signatories include the respondent number 8, who is, my lord, orchestrating this.
Okay.
I have never seen, my lord, this mass petition. And kindly also take note of the alleged date, my lord, of the purported mass petition, 18 July. 27 July, my lord, took the matter. Nobody said anything about this. Nobody. 9 days after the matter was taken up. And whereas a mass petition dated 18 July 26, signed by Shushmita Datto and others, all are assistant teachers of madrasa, so must be including, my lord, the respondent number 8, has been received by the office of the undersigned, wherein removal and change of TIC named my client has been short. So, my lord, now this is punitive action. Stigmatic, punitive. And, my lord, I am not hurt. My lord is insisting over the matter. Therefore, under the circumstances stated above, applications are hereby solicited from willing teaching staff of the madrasa to enable the undersigned to select the TIC. Willing candidates are requested to do so within 3 working days.
Yes.
My lord, he had the courage of, my lord, writing all this, says official records he has seen, omits, my lord, to mention my lord's orders, and, my lord, he is speaking of 18 July mass petition on 10th of August. Now, my lord, kindly take the previous communication at, my lord, page 343 in the same volume, my lord.
Yes.
My lord, the mass petition was of 18th of July. My lord, this is a communication, WhatsApp communication on 6th of August through, my lord, WhatsApp. Kindly, my lord, turn over the page. My lord, I have annexed, my lord, the attachment. Wait. Kindly see me with the subject. Same gentleman, my lord, is signing this, is the author of this also. Regarding service approval of the post of AHM. In relevance with the subject noted above and memo number cited under reference, you are hereby requested to submit to the office of the undersigned positively within 3 days from the date of receipt of this letter, the self-attested copy of service approval. My lord, he knows that my lord is insisting. Issued from the office of DIS, School Education, Malda, for the post of AHM. It is pertinent to note that failing to submit the required document, it will be assumed that your appointment to the post of such and such has not been approved. 6th August, he is writing this silent about the alleged mass petition of 18 July. So, I have reasons to believe this is also something which has been manufactured, procured.
Yes.
Now, I immediately responded to this, in the next page. 346, 8th of August, where I again re-narrated all the facts, the orders, everything. He did not bother to look into my reply, to look into the orders passed by the Honorable Court, to look into the factual situation. And kindly see, this was not the first time that I said so. The 6th August notice at page 343 WhatsApp message was preceded by a notice at page 318.
Yes.
My lord would be shocked, rather, if I may say so, perplexed, to have a look at these contents. 29 July, he is writing, the same gentleman. Subject is request to submit approval copy. Kindly see. A complaint, it should have been complaint, but I'm not on that. A complaint signed by large number of teachers of your school received by SI office against you in different matters of your school dated on 20th July. Kindly tally this date with the date indicated in the last communication.
Yes.
Along with reminder dated 27 July. Does not find mention in the last communication. So it says, so you were requested to come with the copy mentioned above. So his first blush contention was that there is an allegation against you.
Yes.
You respond to that. I don't know, what the allegation is. And then he, could understand that, this would not be the proper way. So, then he, started, chasing me for the alleged approval. Immediately on receipt of this, I responded. My response is, at page 319. I told him with the facts, informed him of all the facts. Then, the second notice, then comes, the third notice. And kindly see, what was my lord's order, the Honorable Coordinated Bench's order at page 120, in the first volume. And the server copy was served on him.
Yes.
Kindly, come to page 120. This is, the order which is subsisting even today. Kindly, have a look at the date of the order, 6 January 2023. Kindly take note of, the name of the petitioner. It's, the respondent number 8, who is, seeking adjournment today. Now, kindly turn to, page 122. I'm skipping over the submissions. Page 122, last paragraph, which starts with after careful consideration.
Yes.
After careful consideration of the rival contentions of the parties and on perusal of the materials on record and on a close scrutiny of the said impugned order dated 3rd November, whereby his candidature was cancelled. 3rd November 2022, this court is of the firm view that to assess the said impugned order, one fact at least needs to be asserted whether in terms of the said government notification, the professional qualification being B.Ed as mentioned therein would cover the said qualification of B.Ed obtained by the petitioner therein. In view of above, the impugned order did not record the finding to such effect. In view of above, the prima facie case and balance of convenience in the facts and circumstances of the case warrant an interim order to be passed by this court. The respondent number 3 shall not issue any service approval. And today he is asking for the approval. The respondent number 3 shall not issue any service approval for appointment in my favor for the post of assistant headmaster if the same had not yet been issued. It is also made clear that the appointment of myself shall abide by the result of the writ petition. Extremely important. So do not disturb my appointment. Do not give approval. Do not disturb my appointment. Whatever appointment I have got will abide by the result of the writ petition. In the meantime, the respondent numbers 3 and 5 shall file their respective reports in the form of an affidavit disclosing all the copies of the relevant documents and records in support of the reason for rejection of the case of the petitioner and appointment of I was not even added as the respondent. Later on, I got myself added there. Such affidavit report should come, etc.
Yes.
Reports have now come, are in my favor. I need not trouble your lordship with those reports today in this writ petition. But those are here if my lord wishes to see. We have the reports. Now, kindly have a look at the last order passed by your lordship at page 340. May I skip over the order passed in can? I'm sorry,
Yes, 340.
Page 340. This is my lord's own order. May I skip over can? The order passed in can. Then writ. Mr. Such and such for the petitioner submits that since the affidavits have already been exchanged, date be fixed for final hearing of the writ petition. Because my future, what would be the outcome of my appointment depends on the fate of the writ petition. Mr. Bari, learned advocate for the petitioner therein, seeks extension of time to put in affidavit in reply to the opposition. Let such reply be filed within 2 weeks. Advance copy may be served. List this matter. The aforesaid direction is made peremptory. List this matter on 11th of August. And 10th of August, my fate is attempted to be sealed. To overreach, this proceeding.
This is
so this is I want a status quo as regards the post of AHM and teacher in charge. Absolutely, in the light of the recent order passed by the Honorable Coordinate Bench, which my lord has also seen and approved of. And what will happen in the previous writ, all of us will abide by the result.
You are for?
For the state, my lord. For the state, my lord.
Okay. I'm also for the state, my lord. Your lordship kindly comes to page 142. Lord, there is dispute between two teachers regarding the post of assistant headmaster. Who will be the assistant headmaster to be decided first? Then, my lord, the teacher in charge will come. Lordship kindly sees, my lord, the petitioner before your lordship is 8. And my lord, the respondent number 8 is fighting in this case, my lord, for the same post. He has, my lord, obtained that qualification to ODL mode. My lord, it is the decision of the Joint Secretary, that is the policy of the government. My lord, that your lordship kindly comes to clause 4.5.
it has been decided by the state government in school education department to import training to all untrained teachers of state government aided school attendance to elementary education means, my lord, from class 1 to 8. ODL mode can be, my lord, allowed as the qualification for BA only in respect of, my lord, elementary education, not for, my lord, secondary or higher secondary. Therefore, my lord, this person, respondent number 8, is not eligible. He has got no
He is not.
qualification.
If he is not eligible right now, we are not
My lord,
deciding on
not
that,
eligible in
Just a minute,
respect of the
sir.
school, which is a secondary school.
which has culminated into filing of a writ petition, is a notice issued by the sub-inspector of schools, being an state authority. State authority says that ODL mode will not accept. We'll decide on the in the other earlier writ petition. In the other writ petition, that is the issue. Now, what prompted 414? Being a state authority, having the knowledge of 12 September 2013 of the notice that the ODL mode is not to be accepted, he went on and says that you provide the approval or you go. Respondent number 8 files a writ petition. There says that you do not, right now you don't grant approval to any of the parties. And it will be parties will abide by the result of the writ petition. In the meantime, you issue a notice. 414. This is a state authority, not a managing committee.
In respect of appointment to the post of teacher in church, my lord,
No.
my lord, the assistant headmaster would be my lord, the teacher in charge is not the law. Anybody from amongst the teacher can be the teacher in charge. Yes, my lord. It has been decided by this court, my lord, that in spite of the fact that somebody is acting as the
No, this is not.
no.
If I tell you, you check it, there is a notice. If there is a headmaster, he automatically becomes teacher in charge. If there is no headmaster,
then
and there is assistant headmaster, he will be the TIC. If there are no assistant headmasters, then this will follow. No assistant headmaster, only assistant teachers are there, then you can adopt this.
Lord, this is not the practice, Lord, because below the assistant headmaster, below the assistant headmaster will be the teacher in charge. There is no law. There is no law. It is from among the teachers.
No
the managing committee will not select.
No.
Here the managing committee is not functioning. Therefore, it is to be done by the person who has been in charge of in place of managing committee. Therefore, let this matter be decided.
This your administrator, who is the sub-inspector of schools, is also a party in the earlier writ petition.
He did not.
He is not a party. But the petitioner has provided the copy of the orders passed in the earlier writ petition. He knows that there is an order by which the court has observed that right now you don't allow any of the approvals to either of the parties, and the parties have to wait for the result of the writ petition.
The golden Seward principle, Seward versus Patterson, that principle follows.
And again, you are issuing notice that you produce the approval. How can you produce the approval? How can you ask the petitioner to produce the approval when the court says that you do not allow any of the approvals to either of the parties?
It is Miller law on the part of.
Then it will be state.
Yes.
The notice will be state. Yes, Mr. No. If you have any objection, you file your affidavit in opposition. Till such period, for a short period, this notice will be stayed. When is the other matter coming up?
Was returnable on 11th, was made on 11th of August. Millard did not come.
Okay.
Millard, we can supply the number again. Millard, any day which is convenient to your lordship.
No.
But Millard, my Leonard at Junior Millard committed a mistake. Millard must indicate that. Possibly my lord's desire was that Millard, both the matters may appear together. Millard, the mentioning slip was handed over. The year was wrongly mentioned, which is why possibly Millard, the previous matter is not appeared. Possibly. Possible.
Not the year, the number.
Oh.
Now the High Court is having 22,000 right
Well,
now.
not possible. Not
Number was given
Milord,
28,000.
Milord, kindly excuse her for that. Milord, I take upon the responsibility. Any day, Milord, which is convenient, Your Lordship. Any day.
Affidavits of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for cancellation and or withdrawal of the impugned notices dated 10th August 2026 under memo number 149/KSC/20264 and the notice dated 6th August 2026 under memo number 148 KSC 2026 issued by the Sub Inspector of Schools Kaliachowk South Circle and Administrator of Majaharul Ulum High Madrasa HS within bracket hereinafter referred to as the said madrasa. 6th August notice is at which page number?
Milord, page 343 and 344. 343 the WhatsApp, 344 is Milord the hard copy.
The petitioners contain that he is the assistant headmaster of the said madrasa. The respondent number 8's candidature for the post of assistant headmaster was rejected by the respondent. Rejected by which authority has rejected the? By the
Milord, I need to check. Kindly see, Milord, by the concerned authority.
Concerned authority.
Grateful.
Which is challenged in this writ petition filed by him.
Yes.
28413.
Yes.
Which is challenged by respondent number 8 in WPA 28413 of 2022. 2022. And in para, an interim order was passed
120, Milord.
On 6th January 2023. After careful থেকে পুরোটা নেবেন এই দেখুন এইখান থেকে 24 থেকে এই যে এটা নেবেন না মডেল para. In the aforesaid writ petitions, directions were issued for exchange of affidavits. And date was fixed on 11th August 2026 for hearing. In the meantime, on 6th August 2026, the petitioner.
Milord, it started from 29 July, page 317.
No, you are agreed by 6th August. 6th August 2026 and subsequently on 10th August 2026, the petitioner received communication from the Sub-Inspector of Schools Kaliachowk South Circle, who is also the administrator of the same madrasa, for producing his letter of approval as assistant headmaster of the said madrasa. In reply, the petitioner communicated the said authority of the orders passed in the earlier writ petition. page 343, 414, sorry. However, by the impugned notice dated 10th August 2026, process has been initiated for appointment of a TIC. In the event since the petitioner could not produce the letter of approval of his service. Being aggrieved and dissatisfied with such communications and the notice, notice, the petitioner has preferred the present writ petition. Mr. Siddhartha Banerjee, learned advocate for the petitioner, submits that the approval of respondent number 8 was turned down by the authority concerned since he was not having regular B.Ed qualification. The respondent number 8 has completed B.Ed through ODL mode. The respondent number 8 has challenged such order passed by the concerned authority in WPA 28413 of 2024, wherein orders have been passed that respondent number 3 will not issue any service approval for appointment in favor of the present petitioner for the post of assistant headmaster at the relevant madrasa. And it has also been clarified that the appointment of the petitioner shall abide by the result of the writ petition. The issue concerning in the earlier writ petition is yet to be decided. In the meantime, such coercive action has been taken for appointment of a teacher in charge. He seeks that the notice as well as 343. You say 343 is the same?
344?
344.
Yes. And we not 414.
Stayed. The letter dated 6th August 2026, within bracket colon, page number 344. The stayed for a limited period. Learned advocate for the state submits that the B.Ed qualification obtained through ODL mode is not an appropriate qualification for considering the candidature of a person for assistant headmaster. Learned advocate representing respondent number 8625, affidavit in opposition. Undeniably, the interim order records that the respondent number 3 shall not issue any service approval for appointment in favor of the petitioner, namely Muhammad Masidur Rahman, for the post of assistant headmaster. The issue whether the petitioner in the earlier writ petition is entitled to be appointed as assistant headmaster on the basis of his B.Ed qualification through ODL mode is pending consideration. The earlier order also records that the appointment of the petitioner shall abide by the result of the said writ petition. Therefore, the notice under challenge, letter and notice under challenge dated 6th August 2026 and 10th August 2026 for producing the approval, letter of approval by the petitioner cannot arise at this stage. Accordingly, is stayed for a period of 4 weeks. Respondent number 8 is directed to file. You will file state, you will file your report. Yes. File 4 weeks, 6 weeks. Within a period of 2 weeks, affidavit in opposition, reply if any 1 week. Release this matter after 3 weeks, report be filed within 2 weeks, exception if any by 1 week. We matter number 10 unit. Release this matter after 3 weeks along with the writ petition being such and such.
May I supply the number?
So your number to the
Now, Milord, I hope it is correct. Yes, it's correct, Milord. I have told.
হ্যাঁ পাওয়া গেছে তো 3 সপ্তাহ পরে থেকে লিস্ট করবেন interim order is till 6 weeks or until further order.
That may take us to the Milord Puja vacation, midst of Puja vacation. Milord, I'll just check. I'll just check.
Then we make it 4 weeks then?
Yes.
Because after 3 weeks this is
kindly make it
you have
4 weeks, Milord. I'll come back and travel your lordship once.
4 weeks.
4 weeks.
Sir, interim order is for 4 weeks. In the meantime, you get 2 weeks to file your opposition. Both the matters will appear after 3 weeks.
So grateful. Grateful.
On behalf of the state, Milord, may it take on from respondent number 4, district inspector of school.
Everyone is directed, Milord, whosoever wishes.
I will not mention you. Find the competent person in your department and file your affidavit on behalf of the state.
Grateful.
Yes. Hearing at least.
My lord, I am for the petition.
My lord, I am for the state, your lordship.
Last question, your lordship directed to produce the fresh report. This is my prayer, my lord, release for new area honorary.
My lord, despite of all sincere efforts, your lordship, we have repeatedly informed them, but we have not received any report from the department, your lordship. That is very embarrassing situation to us also, your lordship.
Everything is clear before your lordship.
Who is the authority then? He has to come before this court and say.
My lord, we just praying for 1 week time, so last chance, my lord, kindly be given for that.
Mr. Vijendra Pratap Singh, learned advocate for this state 6.
Next week, mane chuti hai.
Huh?
Next week, ki chuti hai. Next week.
1 week's accommodation. 26th.
My chuti আছে কি 24?
Chuti আছে.
My lord, 26 is a holiday, I think.
High Court's calendar is not showing holiday.
আমাদের ছুটি I'm good.
34.
State.
My lord, I am.
My lord, the matter has been repeatedly decided by this court earlier, my lord, by giving appointment to my colleagues who are the non-teaching staff and some of the teaching staff. I am the organizing teacher appointed in 1995. And my school, being High Madrasa, Bangor High Madrasa, was approved by the government on 1/5/1996. My lord, in the impugned order, I do not know how and in which manner, admitted my entire cases. But ultimately, and on the last paragraph, he said that no documents filed. That is the impugned order. I will place all the things, my lord. This is the 7th battle of litigation, my lord. I am suffering.
You are teacher?
Non-teaching, my lord.
You say teaching staff?
Teaching and non-teaching, both are running.
Your group D?
Group D. My lord. I was appointed as an organizing non-teaching staff on 1/6/95, and my school has been approved on 1/5/1996. My lord, kindly come. My lord, kindly may I complete the writ petition, my lord. It is my duty, my lord. Kindly come to the para 4. Para 4 of the writ petition, my lord. Page good. Para 4. Page 4. My lord, an order was passed by Justice G.R. Bhattacharya in WP number 8458 of 1997. My lord, when the school, para 4, my lord, page 4, my lord, when the school was approved by the government, my lord, on 1/5/1996, immediately we, the petitioners therein, filed this writ petition and directed to consider the appointment in question.
Just wait.
I guess this is the 3rd or 4th round of litigation.
7th round of litigation.
Which pertains to Madrasa Board. They had earlier completed all the writ petition. And in this present writ petition, I have not been listed as a party. Whereas I had granted approval for the recognition of the madrasa. I guess this is Bangor Madrasa.
Bangor A Madrasa.
Bangor, yes.
40, your lordship may find page 40 of the earlier writ petition. This writ petition, page 40.
And all my colleagues has been given appointment. I am servicing for more than 30 years.
So this number 4. I was the party over there in the earlier writ petition, but astonishingly, he has not treated me a party in the present writ petition.
Page 38 is the first one. First writ petition. Page 38.
Page 38, my lord, kindly.
No. Page 38 is subsequent one.
Page 38 is the third writ petition.
Third
writ petition. My lord, 96 approved, approval
then
given. Thereafter, we are fighting.
8458.
My all the colleagues has been given appointment. My all the colleagues has been given appointment. I have been entangled. Although the impugned order, the director admitted that I am in service and without any break. And pursuant to the direction of Justice Amitabh Lala, an inspection was made in the school, and in the said report, my name is available.
This inspection was made by whom? DLIT?
My lord, the DI.
31.
Page?
Yeah, accordingly recommended. Page 31 of the
On the prayer of the state has filed their opposition.
State actually did not file any opposition.
Then who has filed the reply?
But I have filed the reply against a one-page backdated manufactured order was produced by the then earlier state panel advocate. And we'll see that the order of the DI I do not know whether why they were keeping in pocket. That was dated 25th, possibly. And the matter was adjourned, directing me to take exception to the report. For that, we have filed the supplementary. Thereafter, they have given that report of the DI 1 page.
After supplementary?
After supplementary.
Supplementary.
And that report was dated something 25th, 2025. However, my lord, have given me chance to file to contest the said report dated 29/10/25.
No, after this you have filed supplementary. This is 29th October 2025. Your supplementary is dated 20th January 2026.
But I have filed one supplementary, and thereafter I have filed the affidavit in reply to combat the said letter of the DI, backdated letter.
Okay.
Well, I do not know what they want to contest. I have no objection to spare one copy.
On the
if
prayer
your
of
lordship desire.
learned advocate for the petitioner,
Kindly
leave is
dispose of the
granted.
matter as early as possible. My lord.
Leave is granted to implead Director Madrasa.
They are just watching for long time, my lord. It is running for 4-5 months, 3 months.
Hearing and hearing. Implead
এতো ফোন নাম্বারটা দাও তো না ওটা
Director of
Your Lordship, we are praying to just a leave for file opposition, Your Lordship, against the petition.
Well, 7 time litigation, 7 orders passed, several persons, lefting out me, several persons has been appointed.
কি বললাম? Director of Madrasa Board.
They said page 40, my lord.
Page 40.
Well, his name may be recorded. I can serve the copy to him, my lord.
West Bengal Board, West Bengal Madrasa Education Board. West Bengal Board of Madrasa Education has added respondent number
last
7.
As 7.
Learned advocate for the petitioner, that you hand over copy of the to the added respondent number 7. And file affidavit of service on the returnable date.
Kindly keep it on the next week, my lord. Kindly dispose of that. 30 years I am servicing without any penny, my lord.
Mr. Brijendra Pratap Singh, learned advocate for the state, seeks to file. State is the main answering. Seeks to file affidavit in opposition. Reply you have given, copy of the reply you have given.
Copy of reply to type.
I do not know what I will file.
Another copy.
All the pleadings you have handed over to him because
I will hand over. By in course of this day, all the 3 copies of myself.
Seeks to file affidavit in opposition. You will be filing any opposition? 2 weeks से मुझे affidavit in opposition, reply 1 week, 3 weeks for hearing and distance.
My lord,
whatever opposition you want to file within a period of 2 weeks, give an advance copy to him 1 week after.
Kindly make it 1 week, 1 week, 2 weeks, my lord. Puja is coming, my lord. Before that,
2 weeks is
before that, 3 weeks. After 3 weeks, this will appear. I think 3 weeks will be within puja.
My lord, my lord. Copy আপনি স্টেট রিপ্লাই কপিটা একটু দিয়ে দিন।
হ্যাঁ দিয়ে দিয়েছি, তিনটেই দিয়ে দিয়েছি।
রিপ্লাই কপিটা
হ্যাঁ দিয়েছি।
Next.
My lord, as your lordship.
35. I am for the petition. And last occasion, your lordship, granted leave to file exception, my lord, I am filing my exception. my lord.
Exception. Need exception to.
The petitioner before lordship will retired from the service, my lord, 31st December 2025. Exception copy, sir.
31st December 25.
Yes. Thereafter, my lord, just before retirement, my lord, the TI says, my lord, he is not entitled to get because there is some overdrawn. Overdrawn. Just before the retirement. My lord, immediately, my lord, I went to the school authority as a DI of school. DI has no reason was given, but one letter is given, that is the annexure, that your pay will be, my lord, your lordship can see, this is the last annexure, my lord. That is the page, I'm sorry, page, my lord, annexure 20, page 24, annexure P7. This notice was given to me.
No, this
Page 27
over, overdraw is in respect of what?
My lord, they have not given any notice how much money is what. They have not given any notice. This letter was given.
So, pension payment order has been issued?
No, no PP was given. And now, my lord, what has happened? What they says, now they have submitted a report. Report says, my lord, I within 5 years of my appointment, I have not obtained the BEd degree. This note letter was now, your lordship can see the their report. They submitted a report. But on the basis of the circular where I obtained the BEd degree, but there is no such condition that I have to complete the BEd within 5 years from the date of appointment. Your lordship can see the circular ballot once I have given, that is the annexure ballot page.
In which paragraph it is written that within 5 years he has not completed?
Yes, that is your lordship can see their report. Their report. No, report. Your lordship can see the report.
Para 6.
Para 6. Para 6. But my lord, the circular on which basis, my lord, I got the BEd, your lordship, page 22, annexure P5 of my deed petition. Page 22, annexure P5. There is no such condition. Just within 2012, I have to obtain the BEd degree.
You completed your BEd on which year?
2012. That is a previous page 21.
This is one given granted up to 12.
Annexure P4.
Isn't it? Yes.
And there is a decision of the Supreme Court, my lord. That is, my lord, just I have this in the I have annexed, my lord, in my deed petition, my lord. This page, my lord. Page. Paragraph 18. Paragraph 18, the page 30, page 32. Mitin Mashi. State of Punjab versus Rafiq Masi.
Yes.
Paragraph 18. Is
the copy of the notice by which you have been asked to deposit the overdrawn value, sir?
That is, no such notice was given how much money I have to pay. Only this notice was given an
overdrawn. No, any objection that was noted in the
Yes,
pension
yes.
file? Where is that?
Yes, yes, my lord, that is here. Page. Page, my lord, 24. Page 24, that service appreciations relation documents needed submit and onwards are needed to review as the employee pass bottom, my lord, needed to review as the employee passed B.Ed in 2012 and date of option under RUPA 9 is last date of exam is needed to be submitted for in para 4. C and D dated date of effect of the B.Ed is needed to review. Only this notice was given. No such notice of overdrawn is given. And my lord, till today, my lord, I am not getting any pension.
Yes. You retired as assistant teacher or headmaster? What is your rank? You retired as assistant teacher?
Yes, I retired from myself as an assistant teacher.
But it was January 26. Yes.
I also given the postgraduate scale of pay. That order is I have also annexed, my lord, the page my lord, 20, page 20. Page 20. From last date of examinations.
And they are not challenging this one. Postgraduate scale is not challenged.
Lord, I just
Only that you have not completed B.Ed within 5 years.
Yes.
That is to be reviewed, they say.
But it is the first time I came to know from the report.
No, it's
But it is the first time because my lord, on the basis of the circular, my lord, in that circular, my lord, there is no such condition. You also can see the circular, my lord, once. There is no such conditions. You have to complete the B.Ed within 5 years. That is a page 22 of my date petitions. Page 22. They have stated that you have to complete the B.Ed within 2012.
And postgraduate scale of pay was granted in your favor?
Yes.
In the year 2001?
Yes. From the last date of examinations. 1999. You all should kindly see. Consider last year 5 to 2002. That is a page 20, last line.
Yes. Yes.
My lord, the last para of the report, your lordship, that in light of the above government order circulars, the petitioner would not fall under the purview of geo number such and such. The petitioner was allowed to draw the increment and such and by violating the existing geos. The said observation was duly communicated to the concerned school authority on 9th September 2025. But till date, neither the petitioner nor the school authority taken any step regarding my lordship. In para number 8, the continuation with the stated geo, it reflects no such relaxation for further incremental benefits.
Where this is?
That is report, your lordship, filed by us.
Report dated?
Report dated 27th July.
7 July 2020.
Paragraph 8.
Paragraph 8. Paragraph 8.
Paragraph
Which
8 and
report you have filed? This report does not have any para 8.
হ্যাঁ? এটাই আছে। আছে। তাহলে একটু ভুল।
এটাই তো কারেকশন হয়।
খুরশিদের ইয়ে হলো তো না। ভুল রিপোর্ট দিয়েছে। Copy. No, the copy which has been filed, it does not have. Then this is a wrong copy which you have submitted.
The copy কোনটা দিয়েছো?
Is there any paragraph number 8?
No, there is no paragraph.
Then आपको दिए भी ना।
Mr. Lush, can you take my copy, my lord?
देखिए दी copy.
এটা copy আছে।
Oh, okay.
Your Lordship, I'm just going to, as it is a fresh one, I'm going to just read out the highlighted portion from the page 1, Your Lordship. That no, para number 1, note that the petitioner did not have BA degree at the time of joining in the school. And the second para, Your Lordship, note under ROPA 1998 rules, the incumbent would be entitled to get annual increment after completing 12 months service from his date of appointment. And Your Lordship, para number 4, the notice the petitioner had completed 10 years service on 19th May 1999. After this period, he would automatically eligible to draw the normal increment, Your Lordship. And the next page, Your Lordship, the para number 4, subpara 2.
Para, yes.
Where the petitioner had completed 5 years of approved service.
Then what about 22, page 22? Page 22 of the writ petition says that the governor, after careful examination of all facts and circumstantial cases, have been pleased to allow the incumbents in drawing increments up to 12. As usual.
And during that period, they must have to complete the training.
So within 2012, he has completed.
Yes.
Now the query which has been raised is paragraph 6 of the report, which says that whereas Joint Director made question about entitlement to draw annual increment on 1st July 2006, 1st July 2007, 1st July 2008, and 1st July 2009, which has already been allowed by the governor if a person completes within 2012, as per page 22. In your report, there is no reflection of this letter dated 30th July 2009. Yes.
That is on last paragraph, Your Lordship.
It is there.
That's the last paragraph.
Is a condition?
No. It's a reading. See, in para 4 of the second page, grounds for non-consideration of claim. Whereas the petitioner has completed his 5 years of approved service on 2004. It appears petitioner did not complete B.Ed course during the first 5 years of his service as per prevailing rule. Now the second aspect, this is never in any notification, that the petitioner could not show any document that he made any effort to get admission in B.Ed. the notice in the notification there is no such condition that one has to make an effort prior to claiming. So this interpretation is incorrect. Now come to page 22. 22 has taken into consideration of the teachers who have not completed within the 5 years as per 12 September 1999. In spite of that, the increment has been granted by the governor, stating that those who have completed within 2012, they are entitled to get the increment. So his case is probably this will 30th July 2009, he will be guided by that. What is your prayer?
My prayer is to release the pension. At your page 14. Release the pension and other retired dues.
Exception. Now, affidavit against the report furnished by District Inspector of Schools AC Kolkata dated 27 July 2026 is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities for a release of pension and other retirement benefits in his favor. The petitioner contains that he joined as an assistant teacher in Biniapukur High Madrasa, within bracket hereinafter referred to as the said madrasa. The paragraph this start karo.
1999.
When did you join?
20th May 1999.
20th May 1999 as untrained teacher. You joined as an untrained teacher? Untrained teacher. The petitioner at the time of joining had the qualification MM BA honors in Arabic. The petitioner during his service period completed his masters in Arabic in the year 2001 from Calcutta University and was granted postgraduate scale of pay with effect from 5th February 2002. That is the last date of examination. The petitioner retired from service on superannuation on 31st January.
31st December.
31st December?
Yes.
No, in your letter in page 34, you have
in representation is wrong. 31st, here I have stated page.
In writ petition,
Writ petition, page 7.
The petitioner retired from service on superannuation on 31st December 2025.
Yes.
Page 7. Which paragraph? Yes, yes. However, the pension and other retirement benefits have not yet been released in favor of the petitioner. on the ground that the B.Ed qualification obtained by the petitioner in the year 2012 needs to be reviewed. On 23rd December 2025, the petitioner made a representation before the District Inspector of Schools AC Kolkata for taking necessary steps for calculating the retirement benefits as per the settled principle in accordance with law. Since the pension and other retirement benefits have not been granted to the petitioners, the petitioner has preferred the present writ petition. Mr. Himadri Bodua, learned advocate for the petitioner, submits that the pension and other retirement benefits have been withheld by the respondent authorities on the ground that the petitioner has not completed B.Ed within 5 years of his appointment. Referring to the letter number 759-AC within bracket S/2P-1/09 dated 30th July 2009, he submits that the governor, after careful examination of all facts and circumstances, was pleased to allow the incumbents in drawing increments up to the year 2012 as usual, and during that period they must have to complete such training approved by NCTE. This is the one-time relaxation which is being granted up to the year 2012. The petitioner completed his B.Ed training qualification in the year 2012. Therefore, the petitioners, therefore the pension and retirement benefits withheld by the respondent authorities is arbitrary and not in consonance with the notification of the School Education Department dated 30th July 2009. He seeks for appropriate direction upon the respondent authorities for grant of pension and retirement benefits in favor of the petitioner. Mr. Brijendra Pratap Singh, learned advocate for the state, on the contrary, state respondents, on the contrary, submits that since the petitioner did not complete his B.Ed qualification within the first 5 years of his service from the date of his appointment, his incremental benefits the objection has been raised with regard to annual increment from 2006 to 2009. the petitioner needs to refund the overdrawn amount in order to get the benefit of pension. Para. Upon hearing the learned advocates for respective parties, the only issue which falls for consideration is whether the withholding of pension by the pension sanctioning authority is sustainable or not. Para. Indisputably, the petitioner, while in service, completed his B.Ed qualification in the year 2012. At this juncture, it will be profitable to reproduce the relevant notification issued by the School Education Department secondary branch being number 759-AC within bracket A/2P-1/09 dated 30th July 2009. As here under এটাকে একেবারে তুলে দেবেন italics করে page 22. Upon bare perusal of the aforesaid notification, it is palpably clear that the governor, after careful examination of all facts and circumstances, has been pleased to allow the incumbents in drawing increments up to year 2012 as usual. And during that period, they must have to complete the training approved by NCTE. Therefore, it goes without saying that the petitioner is entitled to drawing of increments since he has completed such B.Ed qualification in the year 2012. Accordingly, the district, which is the authority, sanctioning authorities?
Sanctioning authority, that is
DI.
No.
The district inspector of
DI of the
schools is directed to
DI. Respond number 4.
Respond number 4, AC Kolkata is directed to verify the pension papers of the petitioner and forward the same to the DPPG. Respond number
3.
Director of Pension, Provident Fund and Group Insurance for sanction of pension and other retirement benefits in favor of the petitioner. Such exercise shall be completed within a period of 8 weeks from date of communication of this order. Disposed of.
I am deeply obliged. I am deeply obliged.
At a very outset, I tender my apology. I'm mentioning a matter.
Sure. You are for the contempt, not?
29 for the petitioner, my lord. My lord, kindly sees the earlier order rule was issued.
The requisites you have not deposited?
Deposit,
When did you deposit?
My lord,
where is that receipt? Any receipt is there?
12th July, my lord, it was done, completed.
12th?
12th July approximately.
You don't know?
But can be passed over? I'll take instruction from my advocate on record.
The report says that you have not deposited the requisites.
But then kindly give short passover, my lord. I'll take instructions.
What instruction?
I have been instructed that it has been deposited, all the requisites. My lord, just short parts over, my lord. 10 minutes.
Yes.
Not the query which has been issued. It was fallen from your lordship. If your lordship see the order. The order dated 17th of November 2025.
Yes, I remember.
The respondent number 8 is directed to lodge a formal complaint with the jurisdictional police station, Bhavanipur police station, regarding the alleged act of forgery in execution of the said bond. Then below kindly see the order dated 20th of November 2025. Internal page 3.
27th November.
20th of November 2025.
Yes.
Below third page, relevant portion I am placing. First, second, third, fourth, fifth paragraph from top. The admission of the petitioner is subject to the final outcome of the pending criminal proceeding. In the event the petitioner is found guilty in the said criminal case, his candidature seat allotment shall be cancelled with immediate effect. In such event, the petitioner will be liable to compensate the college as per the bond. A clarification has been sought for by your lordship, my lord. Since my lord, the terminology has been used, pending criminal proceeding, what does it mean? Because charge sheet has been submitted, on the basis of the previous direction, my lord, a PS case has been started, a complaint has been, formal complaint has been lodged, a PS case has been started, on the basis of which the CID completed the investigation and submitted the charge sheet. It appears from the charge sheet that the writ petitioner before your lordship has not been arranged as an accused person. He is also a victim. So the question arises, it was fallen from your lordship that since it is mentioned that the criminal proceeding, that it includes the trial also, after completion of the trial, then he can get the benefit. So what is the interpretation? My lord, if your lordship sees the text and context of the, my lord, all the chronological orders, it appears that, my lord, during the, my lord, after the filing this writ petition, issue came up for the consideration whether a particular document is forged or not. Because it subsequently, after passing the order, it has been brought to the notice of the court. After seeing it, because it is not the Milord the respondent or the university approach before your lordship. It is the writ petitioner initially approach before your lordship only for a direction so that he can get a chance to appear before the authority and he can get a admission over there. So the text and context is that to find out whether he is involved or whether he has conspired or anyway involved in the Milord the mischief which has been done by any of the parties, whether he can take advantage of his own wrong or not by doing mischief. To ascertain this fact, Milord, a direction was given to Milord to file a complaint on the basis of which investigation would be proceeded with. It appears that, Milord, the criminal proceeding I have already consulted with the Milord, the Black's Law Dictionary and everything. What has fallen from your lordship is absolutely correct. It is the dictionary meaning and the normal meaning that the criminal proceeding includes trial. So if, Milord, we can go by this process of the normal meaning or the dictionary meaning, in that event the purpose would be frustrated and it leads to absurdity. So when a interpretation of a statutory provision or interpretation of a in any document or any instrument is required to be considered and it leads to the Milord absurdity, in that event, Milord, second thought is required to be given and purposive interpretation is required to be done. Because otherwise, Milord, if the purposive interpretation would not be made, in that event it leads to absurdity. Today, nobody cannot say when the trial should be, Milord, concluded. If your lordship knows, Milord, even a rank outsider can be impleaded or can be called upon or can be summoned when the trial is going on if the evidence is there under section 319 of the CRPC, previous provision. So this power is there with the trial court. So anytime any person can be arraigned on the basis of the evidence which would be available before the Milord the trial court. So this principle which was fallen from your lordship is absolutely correct. There is no, Milord, the quarrel with the proposition. But the fact remains, if that interpretation will be given, in that event, Milord, a complete uncertainty would be there. We never know how long this proceeding will continue and when that will going to end. Even, Milord, the 5 years court completed, thereafter, Milord, this trial may not be completed. So, Milord, my respectful submission is this, Milord. I am relying a decision of purposive interpretation 2016 3 SCC 619, Milord.
এই ডেটে কোনো নোট আমি নেওয়া ছিল, নোটের ফাইল আছে, নোট নিয়েছি, কোনো ফাইল আছে?
2016 PSCC 619.
Which paragraph?
Milord, I am referring 31 paragraph onwards.
30.
31, Milord. 31, 32 and 33. This is arising out of an arbitration, but, Milord, it has been, Milord, demonstrated as to how the purposive interpretation can be considered and what is that the tenor and which are the, Milord, the cardinal aspects which are required to be considered.
Yes. Take it to show you.
The aforesaid two reasons given by me, in addition to the reasons already indicated in the judgment by my lawful brother, would clearly demonstrate that the provision of the section such and such act requires purposive interpretation so that aforesaid objective purpose of the such provision is achieved. Purposive interpretation so that the aforesaid objective and the purpose of the such provision is achieved thereby. The principle of purposive interpretation or the purposive construction is based on the understanding that court is supposed to attach that the meaning to the provision which serves the purpose behind such a provision. The basis approach is to ascertain what is it designed to accomplish. To put it otherwise, by interpretative process of the court, it's supposed to realize the goal that the legal text is designed to realize. As Barak puts it, purposive interpretation is based on the three components: language, purpose, and the discretion. Language shapes the range of the semantic possibilities within which the interpretation acts as a linguist. Once the interpreter defines the range, he or she chooses the legal meaning of the text from among the express of implied semantic possibilities. The semantic component thus sets the limit of the interpretation by restricting the interpreter to a legal meaning that the text can bear in the public or the private language. Of the aforesaid three components, namely the language, purpose, and the discretion of the court, insofar as the purposive component is concerned, and this is the ratio juris, the purpose of the core of the text. The purpose is the value, goals, and the interest. Policies and the aim at the text is designed to actualize. It is function that the text is designed to fulfill. We may also emphasize that the statutory interpretation of a provision is never static, but it always dynamic. Though the literal rule of the interpretation till some time ago was stated as the golden rule, it is now the doctrine of the purposive interpretation which is predominant, particularly in those cases where the literal interpretation may not serve the purpose, may lead to absurdity, and it brings about an end which is at variance with the purpose of the statute, and that cannot be countenanced. Not only the legal process thinkers such as the Hart and Sachs and rejected the intentionalism as the grand strategy for the statutory interpretation, and in place they offer purposivism, and the principle is now widely applied by the courts, can only in the country but in many other legal system as well. These are the three, although this is on the statutory interpretation, but we have researched that this is the same principles which are required to be followed. But if that interpretation can be given effect to, in that event it leads to complete uncertainty and the absurdity. So with a view to satisfy your lordship's the query, and this is my respectful submission.
Okay.
But I have made my submissions on the last day. I don't want to repeat that. It's on the question of first order obtained by practicing fraud. That's my first case. Now, with regard to what has fallen from your lordships, if we read the order, the intent and the meaning is very clear. Because 2-3 words that those are used in the order, I am extremely grateful that I would not admit that it escaped my notice. I am grateful to lordships that my lord has taken this into consideration. 2-3 words which are very important, and I don't think it leads to any absurdity or anything like that. Kindly see the order that we are talking about.
20th November.
20th November order. The admission of the petitioner is subject to the final outcome of the criminal proceeding. Mr. Dotto has candidly admitted that proceeding will include trial. But kindly read the next sentence. In the event the petitioner is found guilty in the said criminal case, his candidature seat shall be cancelled. Lord, police cannot hold anybody guilty. The duty of the police officer is to investigate on a complaint if it discloses cognizable offense upon registering an FIR, and after concluding the investigation under old 173, they file their report either in final form or in the form of a charge sheet, saying that prima facie the charge is established subject to the outcome of or subject to the approval of the court. Police investigates and give their prima facie opinion that the allegations are established, like in a disciplinary proceeding. The inquiry officer, he never decides whether charges are established or not. It is for the court. Now the police cannot hold anybody guilty of any offense. It is for the court to hold him guilty. Now, if these two lines are read together, the only meaning that comes, my lord, which is falling from your lordship's note, the proceeding would mean the conclusion of the trial. Whether it leads to absurdity or not, that's a different thing. Lord, apropos to the allegations, we have sent him for registration. He is,
registration number
kindly take the first page. Registration number is there. My lord, kindly got that? Yes. And kindly turn the page, my lord. He sat for the exam. Internal exam. Kindly see. MBBS subject, C approved, yes. You approved, yes. Current status approved. So we are not proceeding against him with any vendetta. We have not kept anything without any order of the court. We have immediately sent him for registration. We could not have done that. Lord, as I have earlier argued, Lord, as an institution, it is about the institutional propriety.
Yes.
It is about the institutional propriety, nothing else. We have nothing against him. He is a good student. That is why we considered on day one. My Lord decides the law that your Lordship will decide, we will not, it will apply on us. But the point is, not apart from everything else, when your Lordship will weigh the balance, your Lordship will kindly seize whether a person, whether on 8th of November, he was eligible or not. 8th of November was the date after which he could not have even participated in any further counseling. He's a student of 3rd round of counseling. If he doesn't go and attend the college, he misses all the next chances to attend the mop-up counseling, stray counseling, special stray counseling. He cannot. The door closes from him. He came to court on 11th, shows a document saying that I had this with me. Court accepted it, we accepted it. Later on, it found that the basis on which the order was passed, that's a fraudulent document. So if that document was not there with him on the day when the order was passed, 12th of November, court would not have passed the order. It is 2 + 2 4. If he had not produced that, thereafter what has happened, subject to correction, my little understanding is immaterial. Because fraud would unravel everything. If a boy, if today, I was reading yesterday that somebody impersonated himself as a judge and started deciding matter and granted relief to many. When he was caught, it was found that for 32 years he was continuously doing this. But impersonation, fraudulent document production does not create a right. It can never create a right. Our system runs like that. But I believe it should be, proceedings should be read like that. And my first submission is, he missed the bus on 8th of November. We allowed him to study. We cannot stop him from studying. He is studying there. Now, he will be losing a seat. We will be losing money for the seat. It's not that we will gain something. We can't sell that because that seat will go vacant till the final year. We cannot admit somebody at the second year. First year we admit, it goes up to 5th year. So we will also suffer loss. But our propriety, sense of propriety does not allow us to give up at this stage. That's the only point. And whether on 8th of November he was eligible or not. If he was not, he would always remain an ineligible candidate. It can never be cured. Now, if this is allowed to happen today, then what will happen is, from next time onwards, why we are also apprehensive. My Lord found the MCC also coming and apprising your Lordship in many matters. Why we are apprehensive? Because if this creates a precedent, then we will not be able to stop it.
Right, it is not a precedent. So this is not
that's
stand
not
on
the
it is
point.
not
That's not the point, but
it is not the point. And Milord, at this stage, subject to Milord some kind correction, my learned friend is reiterating the issue that he missed the bus on 8th. That issue has already been considered.
No.
Subsequently, it was your Lordship's pleasure to write down certain questions which was troubling your Lordship. So it is my obligation to clarify it to before your Lordship, Milord. Once again, I do not intend to, Milord, once again reiterate my submission and everything. Everything we have submitted, both of us, and ample opportunity was given to both of us. It is up to your Lordships to, Milord, take a decision about the matter, and whatever, my Lord, the decision we will board.
My application is for recalling of the 12th November order.
Heard the learned advocates for respective parties on the clarification. Put to them regarding the meaning of criminal proceedings. Hearing is concluded. Judgment will be received.
Yes.
We leave everything to my Lord. My Lord, whatever your Lordship decides on, it will go.
Much obliged for this.
Thank you. Thank you all. 136
and 137.
Which file I will take it?
So taking chart 9587 of 9587 of paper book, my lord.
2019. This one?
Yes. Yes. It a paper book.
So you will be referring to the pages of your writ petition.
Yes.
Eight of them.
Hopefully, my lord. Hopefully today, my lord, he finishes.
I will try, my lord. Because my lord, I've gone through the almost, my lord, on the same issue of that resolution and collection of.
You were referring to
Well, I
charge
was-
number 6.
Charge number
6 you were referring to.
6, my lord.
5 you have completed.
My lord. My lord, charge number 7 is page 539. And this is the impugn order, my lord. It has set out the. But this is also similar. Last time I was. This page 539.
Yes.
6 the hoye gache na hockey. 6 possibly, my lord, I have completed. 6, my lord. Regarding your lord, you kindly see page 6, my lord. Charge 6. Delinquent had collected admission fees on different head from 2011 to 13, rupees 170, 190, 200, 220. My lord. Now, my lord, the corresponding is corresponding. I have possibility with 546, my lord. Can you see? But I had argued in this. They have referred to, kindly see, page 546, last 2 lines, last 2-3 lines, in terms of geo number.
Yes.
The appeal committee has said that as long as that amount is under 240 rupees possible, under 240 rupees, it can be taken as school development fees. My argument was that if it is taken as school development fee, it has to be taken as school development fees, and it cannot be broken up into several heads. You again, Lordship, comes back to the delinquent has collected admission fees on different heads from 2011, 2000 to 2013, 170, 190, 200, 220 from several classes, namely from class 1 to 4, by violating the norms without taking any such prior permission from the competent authority. Now, your Lordship will kindly come to page 546, where the appeal committee is dealing with it. Charge number 6.
Yes.
Page 546, with reference to charge number 6. It appears from the report of the inquiry officer that he held the charge as proved relying upon hearing sheet dated 18/8/2014 and the hearing held by him. It appears from the charge sheet that the said imputation was made basing the question number 20 of Exhibit 1 on perusal of the material placed before her. It appears that delinquent admittedly collected fees on different heads from student. Now it is to be ascertained whether she has acted beyond authority or beyond rules by collecting those fees, and whether those fees come within the purview of expression admission fees. He says it appears from the material placed before the fees was taken different heads. He admits this, like school maintenance, examination fees, annual sports, Saraswati Puja, diary, identity card, badge, and miscellaneous heads, and amount varies from 170 to 220. The school in question is a recognized school and aided school, and it comes within purview of subclause 2 of clause N of section 2 of right of children to free and compulsory education act 2009, and not a school established on control by the appropriate government or local authority in terms of GO number 187 SE, dated 14/2/2011. It was made forbidden from collecting any fees for charge of the school established, owned or controlled by the state government or a local authority. And it is further stipulated that no recognized aided school or a school receiving aid or grant to meet whole or part of its expenses from the state government or any local authority shall collect any fee or charges or expenses from a child till completion of elementary education other than development charge up to a maximum of rupees 240. Since the school in question is recognized and aided school, it may collect development fees not exceeding 240. It's taking step by step, only per year from a child. Admittedly, the delinquent being the teacher collected fees ranging from 170 to 220, and therefore the amount was within restricted range as stipulated in said GO. It is also admitted that the said fees was collected on the basis of resolution adopted by meeting of Mothers Teachers Association, and the delinquent only implemented the decision collectively taken by the said association. And since those resolutions were not disowned by Mother Teachers Association at any time before or after the preliminary inquiry, no responsibility can be fixed unilaterally on the delinquent on the plea that she was the head teacher of the school. It was also an admitted position that the admission of any school was not refused on academic year on the ground of non-payment of development fees. Moreover, the term development fees was not defined in the aforesaid GO, and the disciplinary authority has no right to interpret the same on its own wish and whims without referring to the question to the government. The inquiring authority, while making inquiry, did not inquire whether the delinquent acted beyond her authority and came to a conclusion that the basis of surmise expressed on the part of the disciplinary authority, and therefore, in our view, in absence of any clarification from the appropriate government, the aforesaid fees shall be treated as development fees in terms of the GO number 187 SE, dated 4/2/2000, and she acted on the basis of the aforesaid GO, and therefore the collection of such fee itself does not constitute any misconduct, and inquiring authority has heard in factual as well as legal proposition of the said imputation. Well, my contention is, your lordship also kindly sees, this is page 50 questions. Page 50, my lord, possible. Questions, preliminary 345, 50 te nahi hai.
It starts from 337, exhibit 1. I refer. আপনার পেপার বুকে দিয়ে 337 আছে।
আচ্ছা, ঠিক।
50 was in my brief.
Oh, I think this question number 20, lordship.
Yes.
উক্ত অর্থ যে সংগ্রহ করেন তার জন্য কোনো রেজিস্টার মেনটেন করেন তো, কোনো মেনটেন করেন তো, আলাদা করে কোনো রেজিস্টার মেনটেন করা হয় না। আপনার বিদ্যালয়ে মাথা শিক্ষক কমিটি কি অনুযায়ী গঠিত হয়েছে, নিয়ম অনুযায়ী গঠন করা হয়েছে। মাতা শিক্ষক কমিটি স্কুল সংক্রান্ত সমস্ত বিষয়ে সিদ্ধান্ত নেওয়া হয় কিভাবে? আলোচনার মাধ্যমে। কমিটির সাথে মিটিং এর সময় আপনার বিদ্যালয় সকল শিক্ষক শিক্ষকদের উপস্থিতিতে স্কুল এই সংগ্রহ সংক্রান্ত বিষয় কি আলোচনা পূর্বে সিদ্ধান্ত গ্রহণ করা হয়। হ্যাঁ, স্কুল সংক্রান্ত সব বিষয় আলোচনা করা হয়। সকল শিক্ষক শিক্ষিকা গণের উপস্থিতি। This was the whole issue when the committee was formed. The charge itself is that all teachers did not participate in it, all did not sign. So to that, the appeal committee is saying that they were not present, they have not signed. It does not mean anything. The committee is sacrosanct. Committee, under what rules it has been formed, how it has been formed, it has been formed by discussion, not by any resolution of the school committee.
MTA, this mother's teacher.
A committee is formed. It is why this committee is not formed by the school management committee or does not have sanction of law. And the whole basis is of collection of money is this resolution passed in this meeting. And my lord,
kindly, just I am interrupting. Take note of that my learned friend has said that it was done by way of a resolution of the Mata committee. Let that be taken note of, because the charge says that I didn't. Because nobody can challenge the constitution of Mata committee, because that is as per rules. That is as per rules.
So why in question number 22 she says that it has been শিক্ষক কমিটি স্কুল সংক্রান্ত সমস্ত বিষয়
আলোচনার মাধ্যমে that was the way. That's why, that charge has that charge went in my favor. That was as per the GO. There was nothing illegal. If we look into the charge, the charge itself is vague. Charge itself is vague. The appeal committee has taken this all these things. Can this be? This is an informal interrogatory, as in civil procedure code we say. On the basis of this interrogatories, my lord,
that is obviously, of course, not the issue raised, my lord. The whole question was, this is the basis of, she says that I have collected the money on the basis of resolution of this committee. Which is this committee? Where allegation is made against her that all teachers were not present, all teachers has objected. I had submitted it previously. One of the charges was that. Why were they not signed? Well, they were not present. Answer was they were not present, they have not signed. I've got nothing to do with it. And this is the same committee which is the contention on our part, what the teachers refused to sign. Teachers found that it was not possibly, that is from the argument from the bar, possibly the teachers found that the activities of this committee was not correct. So they did not sign. They made a complaint after that. So it has been taken as an afterthought by the appeal committee. Since it was done at a subsequent date and they did not raise any objection, because this is was my reply in another of the charges. Here, my lord, the charge which I am dealing with is collection of money. Your lordship has seen that it is admitted that she has taken money on various heads. It is very clear that she has not taken money on development charges. Their cases and memo says a very strange, the allegation is the school is not authorized to interpret the memo. I am authorized. Appeal committee can make an interpretation. School cannot. School says the only money you can collect is under the head of development fees. You cannot take money for Saraswati Puja, for diary. You cannot take this separately. That is the charge, because they are saying all this collection was bad. And it is not as if the appeal committee disagreeing with this. It says it appears from the material placed before that the fees were taken on different heads like school maintenance, examination fees, annual sports, Saraswati Puja, diary, identity card, badge, and miscellaneous head. And amount varies from 170 to 220. Now, who will keep track? So the appeal committee is not going on to those things. But this will follow, this leads to another charge which will come, subsequent charge.
Okay.
So on this, my contention is that the headmaster could not have collected it, and she has admitted that register is not maintained. I've shown question 20.
Yes.
Register maintain করেন, আলাদা করে কোনো register maintain করেন। Now we'll come to chart 7, 8 and 11. This is page 548. Three charges are being dealt with. My lord, kindly take up the charges first. 7, 10 and 11. Your lordship has seen, my lord, page 548
Yes.
with reference to charge 7, 10 and 11.
Yes, sir.
Page 548.
Yes.
Now, my lord, kindly see with reference to 7, 10 and 11. Now, I will come to the charges. 7 is at the bottom of page 539. Kindly see the nature of the charges which has been raised. The delinquent, my lord has got the delinquent, it is 7, no, 7. The delinquent made interpolation of original amounts in several fees, bill books, with a malevolent intention to show the reduced amount of collection, and thereby she has committed a serious misconduct of defrauding and cheating the school as well as the guardians of the schools, students of the schools. Now we come to charge 10. On verification of the entire documents furnished by the delinquent, fees book as mentioned in para 8 in her reply dated 21/10/2013, and after comparing with the cash book from 2011 to 13, it appears the delinquent has collected admission fees annually from the student to the tune of 1,88,300 only. But on meticulous verification of the enrollment and admission register, the actual amount would be 3,05,000. This is a serious charge, my lord. Only, and thus there was a shortfall of 1,12,170 rupees only, and thereby it appears the delinquent had misappropriated the aforesaid huge sum of money of rupees 1,12,170. 11. On verification and this charge
11.
charge
17 and
11,
11.
Charge 11, page 2. What? 540. On verification and checking of the cash book with all bills and cash submitted by delinquent being enclosed with a reply dated 21/10/2013, para 7 and 8, it reveals that the delinquent has misappropriated another sum of 1,03,365 only as you did not furnish any bill or any voucher relating to the said amount, and therefore the total shortfall amount has come to 2,15,335. Now, I will kindly see how it is dealt with. That's page 548. With reference to charge 7, 10 and 11, inquiry authority has held delinquent guilty of those charges. For this purpose, he relied upon the bill books, cash book, admission register and bill vouchers. Imputation of manipulation on the bill book used for purpose of collecting fees together with misappropriation of amount of rupees 2,15,535 only were labeled against the delinquent. Striking out of a figure, kindly see, this is the appeal committee. Striking out of a figure or a phrase on a document itself does not constitute any misconduct unless it is done with intention for unlawful gain. In the instant case, admittedly, there are some instances of striking out figures on bill books which were used for collection of fees containing the signature of the delinquent. Only this is perhaps one of the direct and most damaging charges, and this is how it is being dealt with. Where you go very happily cross figures across bill books, my lord. But you have to have a malicious intent.
Yes.
So my contention is the very act of this unauthorized striking out and changing figures is illegal. It is admitted by the delinquent during hearing dated 18/8/2014 that whatever collection was made was deposited in the bank account. But to determine these three issues, no statement of conciliation of amounts showed in bank passbook, cash book, and amount collected to bill book was placed on record. In the instant case, it is admitted position that no separate register was maintained for collection of fees, and save and accept bill books and following the principle and rule of best. Now kindly pause here. Well, Ashu, I have just read. She has not maintained the register, and now she has been given benefit of doubt. The delinquent was supposed to maintain a register. She does not mention. Now, I again repeating, my lord. In the instant admission portion, no separate register was maintained for the collection of fees, and save and accept the bill book. And following principle, a rule of best available, the bill books are the basic document to ascertain the total volume of collection. And in order to ascertain the amount of misappropriation, it is required to reconcile with bank statement to ascertain whether the entire amount collected was deposited in bank account according to the admission of the delinquent. But this is not really an admission, this is a contention. Admission of the delinquent, the question of misappropriation arises if any difference is found in the collected amount and the amount deposited in the bank. On perusal, I need not go back. There they have said we have gone through the big documents and we have arrived at this figure. That is not dealt with. That's it. Only because you have not reconciled it with bank. May I read that charge again, my lord?
No, in one portion it says that there is no statement of reconciliation of the amount.
Well.
And in the last portion it says that the misappropriation cannot arise since the difference is found, there is no difference found.
Well.
The last portion, the question of misappropriation arises if any difference is found between the collected amount and the deposited amount. If the statement of reconciliation is not before the appeal committee or it was not collected, then how?
Your lordship is reading at page 549.
548. It is admitted by delinquent.
It is admission of the question of if any difference is found in between the collected amount and the amount deposited in the bank. On perusal of the report of inquiry together with material, find a clear indication that the amount collected. No.
Not this one.
Previous,
it starts, paragraph starts with it is admitted by the delinquent during hearing.
Yes, madam.
The third line, but to determine these three issues, no statement of reconciliation of amount shown in the bank passbook such and such was placed on record. It was not placed on record.
No.
Now the finding in the last portion it starts. See, and the question of misappropriation arises if any difference is found between collected amount and the amount deposited in the bank.
Right.
My question is that if there is no reconciliation statement that was on record, then how can there be an observation
that there is no.
That there is?
Well.
Either say that it cannot be ascertained,
well.
But it cannot say that there is no misappropriation.
No.
That is what I'm putting. Is that
where my lord is reading?
See, it starts with the question of misappropriation, if any.
Misappropriation, if any.
548.
548.
Have you got it?
Yes. Well, and the question of misappropriation arises if any. This one.
Arises.
If
Pause. Arises.
Yeah.
If any difference is found between collected amount, the amount deposited.
Question
Now, if-
arises only when it can be reconciliated. Or if it was reconciliated at all.
No, does not say so. It says that if there is a difference found between the collected amount and the deposited amount,
Yes.
there is no question because he was not in a position to find out whether there is any difference or not.
No, he was not in. Cannot be because the
10-20 minutes.
Your other side is ready.
Sir, don't mind, but
You come back.
Yes,
You come back after. The aspect is that if the record is insufficient and there is want of evidence, the observation or findings would be that the record does not suffice to say that there is misappropriation. But once you say that the misappropriation arises when there is a difference, without there being a reconciliation statement, that is what I am on.
How can there be a difference?
No, I think, my lord, he has said so. What my lord is saying so. My lord, he has said so. It's required to. The appeal committee is pointing out the infirmities. It is saying it is required to reconcile with the bank statement to ascertain whether the entire amount collected was deposited in the bank account according to the admission of the delinquent. So it was not done. And the question of misappropriation arises if any difference is found in between this.
No.
Meant it was not done.
Possibly, my lord, that
So
is
that
possible.
charge itself was, my lord, baseless. That's what, my lord, the appeal committee.
Might
Then,
in
my lord,
any
if
case,
my lord kindly
might-
continues to read, my lord, it will be on perusal.
Okay.
On perusal of the report of the inquiry of authority together with the material placed before, we cannot find any clear indication that the amount collected were ascertained following the rule of best evidence. And the inquiry authority relied upon the report of the preliminary inquiry where the entire collection was ascertained on the basis of admission register. It further appears from the question number 27 of Exhibit 1 that it was resolved by resolution dated 39/2010 that account of fees collected from guardian was to be maintained by committee of 3 persons comprising of head teacher, 1 assistant teacher and 1 Kobita Banerjee, guardian's representative. And therefore, if any misappropriation is detected, not the delinquent alone, but all 3 members of the committee was collectively accountable for the same. And in case it appears to the disciplinary authority that the same amounts to misconduct, he is to proceed simultaneously against the head teacher and the assistant teacher, who was also member of the committee. In the instant case, the inquiry authority neither inquired into act who was entrusted with the fund with the delinquent and how it was to be managed and who was responsible for keeping the accounts of the fund, and therefore the inquiry on this issue remains incomplete and no inference can be drawn on the basis of such incomplete inquiry based on incorrect evidence. Therefore, we are of the view that we came to a misconceived finding, ignoring the rule of best evidence and the other relevant facts associated with imputation, and the same is perverse and in bad interest.
Oh, he has indicated that what is wanting.
He has indicated what he does not goes into what is there. What is the again, my lord, you kindly see the charge at page 548. 548.
541.
540.
Charge number?
Charge numbers. Charge number 7, my lord. 539.
10 and 11,
Oh,
they will do it. Now
7, 8. It appears from the resolution dated. না 7-10 টাই তো পড়ছিলাম, কোনটা পড়ছিলাম? 7-11 টাই তো পড়ছি। School therefore teachers included signed the resolution, only one teacher. না গন্ডগোল হচ্ছে।
7, 10 and 11 you are submitting.
Already done.
আমি কোনটা পড়ছি? আরে অ্যামাউন্টটা 8 পড়ছিলাম তো। এইটটা পড়ছি তো, ওটা এখন ডিল করলাম না। মানে I was actually reading 7, 10 and 11.
Yes.
7, 10 and 11 I was. Seven. The delinquent made internominal.
That you have submitted.
Yes, sir. No, these are been taken together. That is why I am repeating this. 7 says the delinquent made interpolation of original amounts of the fees bill book. This is relevant because they have raised that who was the amount entrusted, you have not said. That was of these 3 charges are being taken together, These charges are being dealt with together. So the question, what the appeal committee says that, firstly, it says that since it has not been reconciled with the bank statement, you cannot know. Then she says who has it been entrusted with, you do not know. Then it says that since 3 persons were involved in what? In passing the resolution. So they say they are presuming on that these 3 persons were collecting the money. Otherwise, why should we proceed against them? One thing is to pass a resolution, one thing is to collect the money. These are 2 separate things. Resolution may be taken by 10 persons, but a person will be collecting the money, not 10 people not sit and collect money. So, my lord, that is why I was going through the charges. 7 is interpolation. This is in respect of bank, my lord. Bank statement. If I find an interpolation, what is the necessity of me reconciling with that is itself a wrongdoing. Now, my lord, 8, 10. So,
10, yes.
8, 10, 7, 10. On verification of the entire document, kindly see, on verification of the entire document furnished by delinquent, fees book as mentioned in paragraph 8 in a reply dated 21/10/2000, and after comparing with the cash book.
Yes.
So it is not as if we are making a thin assumption. We may not be comparing it with the bank account, but I am comparing it with the cash book. There is already a discrepancy in the cash book and the receipt fees book. Fees book and cash book. Fees book as mentioned paragraph reply dated, and after comparing with the cash book from 2011 to 2000, it appears the delinquent had collected admission fees annually from the student to the tune of 1,88,300 only, but on meticulous verification of the enrollment and admission register, the actual amount would be 3 lakhs. So the cash book is showing an amount lesser than what has actually been collected. No bank reconciliation required for this. Admission register is showing some amount. Next book comes the cash book. Cash book does not have those entries. So the amount in cash book is lesser than the admission register.
But then how this charge has been framed that on meticulous verification of enrollment and admission register?
That is what I am saying, my lord. First phase is on verification of entire document furnished by delinquent fees book, as mentioned paragraph 8 in a reply dated 21/10 to the, and after comparing with cash book, from it appears the delinquent had collected admission fees annually from student to the tune of 1,88,300 only, but on meticulous verification of enrollment and admission register, the actual amount would be 3 lakh. So from the enrollment and enrollment and admission register, it is 3 lakh. From the cash book is possibly from the cash only, and thus was the annually from student. Delinquent had, and after comparing cash book, it appears that the delinquent had collected admission fees annually from the student to 1,88,000. So from the cash book, it is 1,88,000.
Yes.
But from the register, it is 3 lakh. Well, kindly read the second part first. From the register, it appears that 3 lakh, which is to be maintained at an earlier stage. Register, enrollment register. There it is 3 lakh. But in the cash book, it collected admission fees annually from student of 1,88,000. Lower amount is reflected in the cash book.
Yes.
Again, on verification and checking of cash book with all bills and cash memos, it is not as if it is on without any evidence. Verification checking the cash book with bills and cash memos as submitted by delinquent being enclosed with a reply dated 21/10/2013. It reveals the delinquent had misappropriated another sum of 1 lakh 1,03,365. The said amount, and therefore only as you did not furnish any bill or voucher relating to the said amount, and therefore the total shortfall had come to 2,50,335. The first amount and this amount, madam.
Yes, yes.
So this shortfall was found based on evidence. The standard of proof in a disciplinary authority proceeding need not be that standard of criminal trial. This is established law. I need not harp on it. So the person who is there, the school authorities, they are going through books and finding discrepancies without any answer as to what has happened to the money. The defense which are being made out by the appeal committee, not by the delinquent. The appeal committee says that this process is wrong. You should have collected it with, checked it with the bank reconciliation statement. You should have initiated proceedings against others. Even if I have wrongly not proceeded against others, how does that help this present petitioner, my lord? Offense against her is made out. So that cannot be a reason because you have not taken action against other. And who are the others? Who had signed the resolution? It is not the case that they were maintaining the books. On the other hand, the headmistress was maintaining the books. At least on the cash memo, on the receipt, it is stated with her signature, where she has crossed and corrected.
Yes.
Charge number 8. And directly reading the charge at 540. Top. This is the charge. 540 to up of the page.
Yes.
It appears from the resolution dated 11/3/2011 and 13/1/2012 adopted in Mother Teachers Association relating to collection of fund, which is against the rules from the guardians of the school, and none of the teachers, including the delinquent, had signed the resolution on 11/3/2011, and only one teacher, being the convener, signed the resolution dated 13/1/2012. And it was presumed that the delinquent, being the then teacher in charge of school, went beyond the guidelines of Sarva Shikha Mission and made assistance to adopt such a resolution against the will and desire of existing teachers, and that had constituted serious misconduct. I'll just go through it. With reference to at page 549, it is being dealt with by the appeal committee. Bottom melon. With reference to charge number 8, inquiry of the held that charge may be considered as proved with the finding that though direct presence of TIC is not ensured by attendance of the resolution, but execution of decision like collection of examination fees indicates her consent and absence from other teachers. Signatures indicates either their disagreement or ignorance. It appears from the charge sheet that the said charges, my lord, kindly see that was something else and it is going on to something else. The appears from the charge sheet that the charge was framed on the basis of resolution dated 11/3/2011 and 3/1/2012. And it is clear from the finding or inquiry that there was no direct evidence that the delinquent in any manner exercised a position for adopting those resolutions, and therefore she cannot be held guilty of the charge. Moreover, it appears from discussion, same mallet, this GO number 187 and GO number 565. It was right to take disciplinary action against the headmisters who were found to be charging any amount beyond 240, and the instance case admitted the amount fees collected from the guardian never exceeded the amount of 240. Therefore, no misconduct was. I need not repeat this matter. There is a memo which says total amount of 240 is the limit of for development charges. It does not say that the total amount collected has to be under 240. development fee should be within 240. It's not as if Saraswati Puja will be different. And it does not say the total amount connected under any head will not be more than 250. Same issue, man. All are interconnected. এরকমটা 9টা করবো তো page 540.
Yes.
540 bottom of this is 9. On verification of entire document furnished by delinquent fee, it's the করলাম নাকি 9 10 কত এটা দেখাচ্ছি 9. It appears from the show cause notified memo number 1524 etc. dated 12/12/2002 together memo number such and such dated 24/12 issued against the delinquent from office of additional district magistrate Howrah with respect to incomplete construction work of head teachers room and girls toilet and refund the allot fund of 3,64,000 only that an act on our part is devaluation of money which is adversely affecting creation of government asset with a direction to refund the allotted money with interest to their end. Else necessary legal action will be taken against you. And the time of hearing on 18/8/2000, the delinquent had admitted to submit the 2 replies of the above noted memos, but intentionally she did not submit the same till yet. And thereby delinquent had failed and neglected to carry out performed duties responsibility to other authorities and and his conduct is unbecoming of a head teacher of the school constitute a serious misconduct. Whether this is a serious misconduct or not, Lordship will be the judge of it. But the fact is, the district magistrate is sending you a letter that some money has been given. You return it with interest. It has not been used, you return it with interest. No reply is given to it. The head of the institution is in charge of each of these functions.
Okay.
It is not, it may be a, maybe the argument could be the district magistrate had not taken any step. But it is a serious lapse. And this is being dealt with at page 550. With reference to charge 9, the inquiry authority did not express any conclusive opinion, and it appears from the findings that the present status of the reply, whether submitted or not, can be verified with the DPS's receiving. It appears from the charge sheet that the said imputation was made on the basis of show cause notice issued from the office of the additional district magistrate Howrah served on the delinquent. It further appears from the hearing sheet dated 18/8 that the delinquent in answer to question number 50 and 52 admitted that she submitted reply to such show cause notice to the issuing authority and the charge was framed without verifying any material supporting the contention of the charge. And it was clear from the contention of the charge that the same was framed by drawing an adverse presumption against the delinquent. Under the law, the charge is to be framed where there exists grave suspicion arising from the material supporting the charge, and no charge be framed on a mere suspicion. There is, I will pause here, there the appeal committee is on the go making up laws. Charge sheet is not on approved misconduct. Charge sheet on a suspicion of misconduct, where we have some prima facie case at that stage charge sheet edition. Inquiry officer will inquire into it. Defense will give their documents. The first part, he says, it appears from final reply, it appears in charge sheet that the imputation made in further that the delinquent and answer the question 51 admitted that she submitted reply. Now it is for the delinquent to bring those replies on letter on record. I am very sure those letters have not yet been even in the writ petition, they have not been brought on record. I will leave it at this. The charges, no charge can be framed on mere suspicion. In the instant case, charge number 9 was framed only on the basis of so-called notice without referring the end result of the same, and the charge itself does not constitute any misconduct and framing of very charges onerous.
Only one signed plea, other matters so far 2 PM, your lordship will not take.
Which matter?
Mine one was 82. That is the reason I was sitting.
After this, there is a fixed matter.
I will be waiting.
Charge 12. Filter go to 541 last.
135 আছে না?
12 টা তো? The 12, my lord, is a very.
After this, there is a fixed matter.
So
So
hopefully,
probably it will not be possible for taking the specially assigned matters today. This will be continuing. I have a question that the charge number 9.
My lord.
Charge number 9 says that page number is
Page number, my lord, charge number 540.
just now you have
540 is the charge.
9. Now, once a fund is allocated in a government office, it's not paid in cash. So allotment goes to the account of the particular school. If it is not utilized by 31st March, then it again goes back.
Right.
With interest, or because the headmaster or particular person in charge has nothing to do with that. If he or she fails to,
It is not as if
use
he-
that
I
particular fund,
understand,
it
my
goes
lord.
back.
But this charge has been very carefully framed. The charge is not in respect of misappropriation of money. The charge is that you have not replied to their show cause. Well, kindly keep it limited to that. It is only not non-replying to the show cause, nothing more. There is no allegation that you have misappropriated this amount.
In the inverted comma, with the language is that a direction to refund the allotted money with interest to their end, else necessary legal action will be taken against you.
This is what the DM is saying.
Yes.
Yes, sir.
So once a fund is allotted, not utilized, it goes back to the account. So there is no question of it.
It has possibility to be sent back. It has to be sent back. It does not automatically go back. So this
you
was
just clarify on this issue, because whether this
এটা দেখো না এই যে ডিএম এর এটা
it has been marked as exhibit. Mr. Ghosh?
এটা এক্সিবিট আছে ডিএম এর চিঠিটা
To the extent that I can recollect, probably has not been marked down.
Okay.
এটা কোথায়
This memo number of
If your lordship is asking me, my lord, fund given, utilized, not entirety, part utilization, because to the extent utilized, my lord, to be certified, part utilization certificate given as a matter of reply, and my lord, once that was done, the chapter closed. Because my lord, the authority also didn't ask for return, because as your lordship said, this is also not there. Their question, as my learned friend is saying, and the charge is saying, why didn't I reply?
Well, I'm limiting myself. Charge is limited.
Fact is, my lord, the authority who is seeking the reply is not offended, because it's a misconduct, insubordination, if I exactly use the language. That authority is not agitated. My lord, this disciplinary committee, this school, and my lord, the DI, they become agitated. And they, my lord,
that in my
and
in my opinion is not a good defense.
And my lord, I can show to your lordship, my lord, those documents were there before the appeal committee. Those are not taken into consideration because, my lord, the evidence in that sense, but part utilization certificate was conveyed and the matter dropped there. And that document is still with us.
Well, even before the order, High Court, if they can produce, that is sufficient.
Right now, I can give it. Right now.
Okay.
The charge is very narrow. You have not replied. Their answer will be only one, nothing more. That it has been replied to. Oh, nothing more, man.
Okay. We'll see that.
But
next.
But Malla, the appeal committee makes a mountain out of a molehill. So, my lord, I do not know. What are the the lordship has gone through so many charge 12. Let me finish charge 12, my lord, because there is more after that. Page 540, 541. The preliminary report submitted by the Additional Inspector of School, Howrah, this Your Lordship 541, page 541. The last charge, madam. Page 541.
Yes.
The preliminary report submitted by the Additional Inspector of School, Howrah, and the Sub-Inspector of School, Sadar, North Circle, Howrah, White Memo number 521, dated 8/8/2000, against the delinquent corroborated the aforesaid charges. I am presuming it is referring to the previous charge. There is no imputation, my lord. I will be very frank with this.
Yes.
On perusal of so it is dealt with reference to charge number 12. It is held by at page 551. Held by inquiry officer that the charge has been proved as per exhibit, and on perusal of the charge sheet appears that no imputation is attached to this statement. That is a mere opinion of the disciplinary. It does not constitute any misconduct itself. Therefore, charge under this head is non-est and does not require any adjudication. Now, my lord, paragraph 12 is a general statement which well said that it is a departmental inquiry. Inquiry authority performs the quasi-judicial function. He has come to a logical conclusion upon etc. The instant case, the finding of the inquiry authority on each charge are cryptic in nature. I am reading from page 551. After the charge.
Yes.
It is paragraph 13. Instead of finding each charge are cryptic in nature, and in many places he did not specify the evidence on which he placed his reliance. In sub-rule 3 of rule 9 of conduct rule, it clearly needs the inquiry authority to submit his report on an assessment of the evidence in respect of each article of charge and reasons thereof. Practically, the inquiry did not make any assessment of evidence and did not put any reasons in favor of his conclusion. Moreover, it is apparent from the inquiry on charge number 1, 2, 4, 7, 10, 11 remain incomplete, as he did not make any inquiry on the inquiry or the relevant facts, the existence of which are very apparent. At the time of hearing, the learned advocate appearing for the respondent submitted there is no denial on part of the delinquent, as the departmental proceedings proceeded ex parte. It is well settled principle of law that the party proposing to adduce a particular evidence knows the purpose for which is to be adduced, and he is to take all precautions for the proper evidence to be adduced to prove the factum of the acquisition, irrespective of fact whether it is proceeded ex parte or not. Since there is no separate conduct rule for teachers or TIC, there is no scope for disciplinary authority to treat the assistant teachers in one scale and the head teacher TIC in different scale matter of misconduct. It is also established principle that the disciplinary authority cannot designate or or any act of omission misconduct that is whims on caprice. In other words, disciplinary authority has no right to go beyond conduct rules to determine what are misconduct, what are not. It is evident from the above discussion that disciplinary authority by framing the charge travel beyond West Bengal primary education conduct of service teacher rules and frame charge number 3, 6, and 8 without ascertaining whether those came under purview of misconduct or those which are declared as misconduct by any rules or circular or government order notified on behalf of appropriate government. It further appears that the charge number 9 was framed on the basis of surmise as discussed in the preceding paragraph and settled principle that grave suspicion cannot be replaced by mere suspicion. Charge number 12 has no element of imputation, rather it bears opinion, repetition. Therefore, the framing of charge 3, 6, 8, 9, and 12 are arbitrary and beyond scope of departmental authority.
Will also release the other matters because it will take time, I think, Malad, as the way it goes. Only one thing, Malad, keep it before 31st. Because 31st, now we have heard the state has moved an application before the Supreme Court for extended the time.
How long is the interim order?
31st. But I can't pray before a loss of extension beyond 31st because Supreme Court said 31st. I can't do that. So that's why I'm praying your losses 27, 28, somewhere keep it your losses. Because that has to be, otherwise, Malad, we will be non-suited.
Mr. Dasgupta,
Well,
I just take the matter which is mentioned by Mr. Sannal, thereafter come back. Just wait. We filed the
That's it. Well, I'm ready to do the matter otherwise. But since your lordship in the midst of another matter, let us finish that. My case is that 31st, your lordship has protected me. They are asking me to go to primary school. I will argue that that will be a very preposterous situation. State should not adopt that stand.
Okay.
But your lordship, they have already, I am told, state has already moved an application for extension. Today itself, they have filed it.
Is it so?
They don't have the instruction. But my client maybe more. But
The interviews have been completed. No.
Interview complete. Interview complete. Counseling not done. Then everything stalled because of that, my lord. Government changed, then everything stalled. OBC now is another.
Date to the 31st আগে একটা date বলো।
ওই তো এসছে। তুমি কোনটা তো স্টেট এসেছো
ভালো করে দেখে নাও, আমি পৌঁছতে পারছি না তো।
এক্সটেনশন আমি মেরিটই করে দিতে চাইছি, কিন্তু এক্সটেনশন তোমরা আজকে সুপ্রিম কোর্টে অ্যাপ্লিকেশন ফাইল করেছো, তুমি জানো ইনস্ট্রাকশন আছে, দেখেছো? আমরা কত ফাস্ট দেখ।
তুই তো প্রাইমারি স্কুলে তোর কন্ট্রোল না, তোর ভর্তি ভাবে এটা প্রাইমারি নয়, এসএসসি কিছু
কোন স্কুল ইউনিভার্সিটিটা আমার কন্ট্রোলে নেই বলো তো?
দুটোই প্রাইমারি স্কুলের ভর্তি করা হচ্ছে।
কোন স্কুল ইউনিভার্সিটি
একটা দিয়ে বসে
লোকনাথ তো ন্যাজে গোবরে হয়ে গেল সেন্সাস।
এটাকে তো প্রায়োরিটি নিয়ে আসতো, শুনতে পাচ্ছি না, ডেট দিচ্ছি হচ্ছে না। 27th রাখুন, 27th রাখুন, 27th কি থার্সডে? 12:30 সময় দিন তো।
চাকরি করতে
অনেকগুলো ধরে নেবো তো। 27, 12:30.
Now, one thing, one prayer, your lordship, similar other matter in another district, your lordships kindly take it up along with same matter. One blow can be finished.
There is stay in this matter? No.
No, it is malad against already extended up to 31st by the council itself.
Oh.
So I need not argue.
Malda.
Not, that is not. This is Malda. I will give the notice.
This matter, no, we are not listing. This matter will take it up on 27.
Then I malad with notice I will mentioning it before. That would be proper. The notice did not mention. 27, 12:30.
In the other matters, they have filed their opposition? No.
Oh, no, this is for the first time. The same plea will be taken. Stay or same plea.
Give a notice and then mention.
And then, but
7, 12:30.
But a formal order needed, my lord.
Why?
Why should I say losses?
I was not taking up the record. I was hearing you.
That's well okay. কাদের জন্য তুমি কোনটা ফিলিং করতে পারছো বলো না, সব করতে পারো।
এটা কোনটা? Yes, Mr. Dasgupta.
Paragraph 15, my lord, page.
Yes.
Right. Since there is no separate conduct rules for head teacher or TIC, there is no scope for disciplinary authority. So, also principle that disciplinary authority cannot designate or, well, this second part is important. It is also established principle that the disciplinary authority cannot designate any act or misconduct as misconduct at his whims or caprice. In word, disciplinary authority has no right to go beyond conduct rules to determine what are misconduct and what are not. He does not refer to the conduct rules. It is evidence, he says that there are no separate conduct rules. First part he says. It is evident from the above discussion that disciplinary authority, while framing the charge, travelled beyond the West Bengal primary education conduct of service of teachers of primary rules. Say another. And framed charges number 3, 6, and 8 without ascertaining whether those come under the purview of misconduct or those which were declared as misconduct by any rules or circulars or government order notified on the behalf of appropriate government. It further was framed basis surmise, etc., replaced by mere suspicion. Repetition, my lord, has no element of interest. Charge number 3, 6, 8, 9, and 12 are arbitrary beyond scope of department. Before proceeding with the department, and any authority must be satisfied itself that the allegation, imputation, or misconduct within the meaning of the rules to which the delinquent is a subject. Act or omission which is not declared as misconduct in the service regulation is not open to the disciplinary authority to fish out some conduct as misconduct and punish the employee even though the alleged misconduct would not be comprehended in any of the enumerated misconduct. For this purpose, the reference is made to decision of Honorable Apex Court reported in 1985 proofs of SCC, page 35. So far, charge number 1, 2, 4, 7, 10, and 11 are concerned. The inquiry remain incomplete, and inquiry authority did not make any effort to collect any evidence on the relevant facts, as discussed specifically in para 11, and therefore he subscribed wrong findings on these charges. And in opinion, this is required to be revisited with fresh inquiry. So far as charge number 5 is concerned, the evidence adduced in support of charge is not sufficient to bring home charge, and we don't find any justification. It is settled principle of law and order imposed penalty by constitution must be supported by reasons for. The speaking order will act at best be reasonable and would worst at least a probable one. In instead of finding of the inquiry were merely cryptic in nature, and no reason was assigned for reaching the finding, and the report was prepared in contravention of Rule 9(3) C and D of the said conduct rule. Disciplinary authority, while accepting the report of the inquiry which itself was defective, made an attempt to cover the lacuna left by inquiring authority in this report and in some charges. The disciplinary authority went beyond the finding given by the inquiry officer.
Yes.
Therefore, considering the facts and circumstances, page paragraph 22. Therefore, opinion the order of dismissal passed by chairman of the respondent council against the appellant dated 12/4/2000 is liable to be set aside in light of observation made in preceding paragraph. It would be appropriate for issuing direction to conduct a fresh inquiry on the charge being number 1, 2, 4, 7, 10, and 11 strictly in light of the above observation made in subpara 1, 2, 5, and 7 of paragraph 11 under the heading of decision with reasons against the appellant for logical conclusion of the prayer. It is into the conduct of fresh. The writ petitioner or the teacher, my lord, has possibly filed one of the appeal challenging this part of the order.
Okay.
Hence, it is ordered that the instant appeal being 30 is allowed on contest, and the order of dismissal of appellant from service, the clause of disqualification for future employment as teacher dated 12/4/2018 passed by the chairman DPSC Howrah, set aside with the direction to cause a fresh departmental inquiry with respect to charge number 1, 2, 4, 7, 10, and 11 of the charge sheet dated 9/12/2014 in the light of the observation against the appellant, after giving her sufficient and reasonable opportunity of being heard to conclude such inquiry within 3 months from the date of communication of the judgment, and order treating the appellant as if she is under suspension for uninterrupted period since the date of order of suspension. The chairman DPSC Howrah shall be at liberty to appoint a fresh inquiring authority if the earlier inquiring authority is not available at his disposal. The rest charges will be treated as dropped. Well, this first part is, we are already agreed by the same part, where it has been sent for fresh inquiry, and this part, where certain charges have been dropped. The charges which have been dropped, my lord, is ওইটা কোথায় আছে প্যারাগ্রাফ 15 one of the major part of this decision is that the misconduct was not defined. So according to the appellate committee, if it is not defined in the rules, the disciplinary authorities cannot impose any, cannot describe any act as misconduct. This is a very important aspect. Because, my lord, there are two specific lines of judgments on this issue, my lord.
In that aspect, you refer to Rule 8.
That is why I respect to Rule 8. My lord, we kindly see Rule 8. In fact, if your lordship goes through the rule, well, the rule itself does not describe any misconduct. There are rules which says that these things will be misconduct. It does not say anything. It just talks about penalty. Now the language is very important. The following
And,
penalty for
you're reading from the education manual?
From my lord.
Education manual?
Education manual is just no. I have translated the law.
Sri Ghosh, it's in education manual.
That it's in the education manual. I
Volume
referred to
1.
Volume 1.
Okay.
Then আমার দিন আমি বার করে দিচ্ছি। Conduct. Have you voted? Have you voted?
Well, in fact, my rule 1 is just the rule shall be called, etc. shall apply to definitions, general definition. 3 is duties. It does not define misconduct, it says duties. What are the duties? Then shall rights, obligations, annual performance report, suspension, penalties. The following penalty may for good and sufficient reasons be imposed on a teacher, namely censure, withholding of increment, removal of service, dismissal of service, which shall be qualified for future. They will be qualified future employment as teacher. Now, my lord, this word good and sufficient reason is very important.
Yes.
Now, ये दाओ प्रिंटो. Extra copy है? नहीं. This is reported in 1997 3 SCC. 1997 3 SCC, page 387. Secretary to the Government and Others versus ACJ Brito. Now, previously there was a judgment in respect of A.L. Kalra, where this was decided, my lord. This issue was decided. At that stage, this judgment is coming. Well, kindly see paragraph 7. I need not take your lordship through whole of the judgment. Paragraph 7 onwards, my lord. What was
just a minute. Yes.
What was, however, contended on behalf of the respondent was that in absence of any rule treating non-compliance with an order of superior police officer or non-appearance before a medical board as an act of misconduct, no disciplinary proceeding should have been initiated against him for the said of act of delinquency. It is support of his submission learned counsel relied upon decision court in A.L. Kalra and Project Equipment Corporation of India. In that case, disciplinary proceedings were initiated against A.L. Kalra by the corporation for committing an act of misconduct under Service Rule 411 and 3, which prescribe that every employee of the corporation shall at all times maintain absolute integrity and do nothing which is in unbecoming of public servant. Rule 5 prescribed various misconducts. This is important. Rule 5 prescribed various misconduct for which action could be taken against the employee government by rules. Taking note of the fact that Rule 4 was given in the heading general and Rule 5 was given in the heading misconduct, this court took the view that the draftsman of rule made a clear distinction about what would constitute misconduct. It was under these circumstances that this court observed that failure to keep such high standard moral, ethical, or decorous behavior benefiting an officer of the company by itself cannot constitute misconduct unless the specific conduct falls in any of the enumerated misconduct in Rule 5. Rule 4 was regarded as vague and of general nature, and in that context it was further observed that where misconduct when proved entails penal consequences, it is obligatory on the employer to specify and if necessary define it with precision and accuracy so that any ex post facto interpretation of some incident may not be camouflaged as misconduct. Construing the rules in this court held that Rule 4 styled as general specifies a norm of behavior but does not specify that its violation will constitute misconduct. Rule 4 was thus constituted not specifying a misconduct. Thus, the decision in that case turned upon the scheme of those rules and construction placed upon Rule and 4 and 5 of the rules. This court in that case had not laid down as a general principle that if an act is not specified by the rules to be a misconduct, then it cannot be regarded as an employee cannot be punished for committing such an act. Observation by the court in Ranjit Thakur versus Union of India support the view that we are taking. In that case, the question which arose for consideration whether a disregard of an order to eat food by itself amounting to disobedience of a lawful command for purposes of Section 4 of the Army Act 1950. This court observed that the question has to be examined in context of imperatives of a high and rigorous discipline to be maintained in armed forces. Every aspect of life of a soldier is regulated by discipline. Rejection of food might, under circumstances, amount to an indirect expression of remonstrance and resentment against the higher authority. To say that a mere refusal to eat food is an innocent, neutral act might be an oversimplification of the matter. Mere inaction need not always necessarily be neutral. Serious act of calumny could be done in silence. A disregard of a direction to accept food might assume the complexion of disrespect to and even defiance of authority. The rules applicable in this case do not specify act of misconduct for which a delinquent officer can be punished. Rule 2 empowers the competent authorities to impose upon the members of the service penalties specified therein for good and sufficient reasons within courts. We have shown the same line in our exact line. Therefore, the decision of the court in A.L. Kalra case is clearly distinguishable. Before holding that there was no justification to initiate disciplinary proceeding against the respondent, the tribunal ought to have considered where there was good and sufficient reasons for initiating such proceeding against him. It was not justified in taking the view on the ground that an act of delinquency has not been specified in the rules as an act of misconduct. Not obeying a legitimate order of superior member of police force has to be regarded an act of indiscipline and would certainly provide a good and sufficient reason for initiating a disciplinary proceeding. So, Mala, this is in respect of repeated and very emphasized observations of the appeal committee. that in respect of these charges, the rules were not, these were not misconduct as per the rules, my lord. This is paragraph 10. He is stating this appeal rule form the basis of etc. And in respect of charge 3, he has said was obliged under rule. It is not clear neither from report of inquiry authority nor from material placed before us on behalf of the disciplinary authority as to whether delinquent with the head teacher was obliged under any rule to act in a matter stated in the imputation. Authority to it is not open to authority to designate any act or omission as misconduct, and therefore in our opinion the performance of any act which is not mandatory under any rule is not a misconduct. This is exactly the case with Brito case, my lord. I just referred, my lord. The charges 3, 6, 8, 9 and 12, my lord. He has dropped these charges. 3, 6, 8, 9 and 12. कोणता? Velraj? None. Government of TN1 others. Also almost on the same issue, my lord. This is 1997 2 SCC 708.
আগেরটা ছিল 3 SCC।
এটা হচ্ছে 1997 2 SCC 708. Government of TN and others versus Velraj আলাদা আলাদা।
Which paragraph here?
Paragraph 6. Learned counsel for the appellant was also right in its criticism that the tribunal transgressed its jurisdiction in examining the evidence as if it was an appellate authority. The law on this point is now well settled. The tribunal obviously committed a mistake in re-examining the evidence and holding that it did not deserve to be accepted because the inconsistency therein. The tribunal is not holding a criminal trial and therefore ought not to have exonerated the respondent by holding that it was not proved beyond all doubts that the appellant has consumed prohibited liquor. The finding recorded by inquiry officer and confirmed by appellate authority were based on evidence led during inquiry, and it was not even contended that the said findings were perverse. It was therefore not open to tribunal to record contrary findings and to hold that the charge against respondent was not proved. The tribunal was wrong in holding that what was alleged against the respondent did not amount to an act of misconduct under Rule 2 of the rules. Punishment can be imposed upon a member of service for good and sufficient reason. Therefore, the tribunal ought to have examined the case from that angle. The respondent, when he appeared before PSI at 8 p.m. 7/7/1984, was on duty. He had returned to the police station for reporting to PSI as to what he had done regarding directions given to him earlier. At the time, he was found in a drunken condition and was in Mufti. He had even admitted before the PSI that he had consumed arak and was, for that reason, he was smelling of alcohol. In this context, we were required to consider whether there was good and sufficient reason for initiating a disciplinary proceeding against him, imposing that punishment for compulsory retirement. Police force has to be a disciplined force, and remember, police force has to behave in a disciplined manner, particularly when he is in total. The respondent, even though he was sent for official work, was on duty. Returned the police station Mufti, and in drunken condition after consuming, he had returned to the police station to report to his superior officer to what happened in the work. His behavior is to be regarded as the act of gross misconduct. It is difficult to appreciate how the tribunal could persuade itself to take a contrary view. In view that facts and circumstances, of this case, it is not possible to say that punishment which was imposed upon him was highly excessive. The appellant authority, etc. So I am just that is the only reasonable part of those two parts. That when the law is otherwise, because if the rules it is very simple, it is bifurcated into very clear distinction. One, whether rules say what are misbehavior, what are misconduct. In that case, every act against on which charge is raised against him will have to fall in one of those categories. I cannot make any charge which is not within those categories. There may be some terminologies used which are much wide. I will have to use those stuff, but I cannot make up any act which is not does not any fall squarely on those parameters as misconduct. It's very clear. But there is other section where it has not been
Defined.
Where it is not been defined, my action of describing an act as indiscipline is always subject to review. If it is absolutely arbitrary, the court can always quash it. However, in this present case, these acts have some merit. Not only some merit, these have grave implications. It is not as if these disciplinary proceedings were not being done by the school authorities. We are not the school authority. The council, when the council is the disciplinary authority, council is conducting, it is an impartial authority. I am not taking a lordship as the final order, because the final order has much on a better footing. Because the final order has not been dealt with and deliberately not relying on it. They have just used that the final order is without even referring to this final order. Because the inquiry officer's report is not final. If necessary, I will show judgment where the disciplinary authority has in its power to reappreciate the evidence, differ from the inquiry officer. So, that is the final order. But since he has not dealt with it in any manner, only very summarily possibly it has been dealt with. Last paragraph. One paragraph. One paragraph. I just wanted to go paragraph. ওইটা আমাকে বলো না কত যেখানে লাস্ট এন্ডিং আছে এর
You will conclude today, Mr. Dasgupta. You will conclude today.
No.
You will take some time.
No. I will conclude. This is. I was just referring to that I have not referred to or taken a lordship to the final order because it has been dealt with very summarily. I just wanted to show the part where he was dealt with it. Just in 2 lines, it has been dealt with. End of the.
Just go through that. If anything is left out, you make your submission on the next day and conclude by 15-20 minutes. You conclude that thereafter.
I will know only that.
Bolo? Short that one. Heard Mr. Indrajit Dasgupta, learned advocate representing Howrah DPSC. Due to paucity of time, hearing could not be concluded. Is this matters on dutu ache. 3rd September, Mr. Ghosh. Mr. Ghosh. 3rd September.
3rd September.
দেখে নিয়েছো? 2nd হবে না? কটা হলো?
আমরা আজকে
2:30
আজকে আমরা কত আছি কত তারিখ 18 সেপ্টেম্বর কোনো মামলা ফিক্স নেই তো 4th September ফিক্সড আছে
রিভিশনটা রাখবে না?
এটা আমার ব্রিফের সঙ্গে রাখ
29 WPCRC. Password down.
29.
Lordship, item 29, Lordship had from seeking for a week's accommodation, Lordship.
The report
Rec-
is received from the
requisite-
department saying that you have not submitted the requisites nor the special messenger's cost. How the rule will be served?
Indeed, Lordship, for that I'm seeking for a week accommodation, Lordship. We had sent through affidavit of service. We have sent a copy, Lordship. The Pradhan had received also, Lordship. We have an affidavit of service, but through special messenger, Lordship, requisite is still not there with me. For Lordship.
You have not submitted that.
No, Lordship. For that reason, I'm praying
It is
for
the
a week.
report of the Assistant Registrar MD2 dated 18th August 20, Mandamus 2, 18th August 2026. It appears that the learned advocate for the petitioner has neither deposited the required copies of the contempt application along with Talabana nor the special messenger cost has been deposited. No, not deposited, not the special messenger cost. Learned advocate for the petitioner seeks 1 week's accommodation to deposit the requisites as well as the special messenger's cost. Please this matter এক সপ্তাহ 10 দিন পরে 15 দিন পর রাখো।
Lordship, my affidavit of service.
What is this?
Lordship, the order was communicated, Lordship.
I didn't direct for filing any affidavit of service.
No, Lordship. But Lordship, we had communicated the order to the, we had,
Instead of special messenger, the clerk communicated by registered post. That was the problem.
You didn't see that.
Lordship, today we,
I'm fixing a date. In the meantime, you deposit all the requisites.
Major.
Come back and inform this court that that has been done. We get a report from the department whether they have received, and final direction will be issued for serving the rule.
Major.
In for a date board. Criminal রাখো।
To appear for the petitioner, kindly recall this that matter. Settlement occurred not in 2007. Last Wednesday, it was appearing before Lordship when your Lordship was pleased not to call upon the parties to come in person. Now, Lord, I'm given to understand the opposite party in whose favor this 138 proceeding, the check was drawn. He has not come to court, and Lord, I'm given to understand that he is no more interested in the matter even. The two
Lordship,
questions.
Lordship, yesterday, Lordship, the matter was mentioned before Lordship, stating that there is some difficulty of the opposite party to appear.
When he will appear?
Lordship, with regard to that only, Lordship, we are the victim of the case, Lordship. Pursuant to the Lordship's direction, we had settled the matter. Lordship, there is some difficulty. If there's any problem with it, Lordship may keeps it out of the list because Lordship, we are facing some issues.
But out of the list, there is a warrant not pending against me. That warrant is
We are the victim. We had settled pursuant to Lordship's direction and pursuant to the appellant approaching us, Lordship. At this moment, Lordship, if there's any dispute, Lordship, let the first appellant satisfy your Lordship with regard to the queries which your Lordship had raised. Legal issues, amount, Lordship.
No, you are not interested to settle. Because an application has been filed, joint application with the signatures and all. That's why I asked the clients, both of you.
only to verify whether it is
whether
done
it has
in
been filed or
exhaustion
not. Whether the intention is to resolve the issue or
Let's indicate one thing here. Lord,
Your Lordship,
they have not
done
affirmed.
virtually to be present, Lordship.
Why?
Physically, Lordship, there is some difficulty for the opposite party to come here, Lordship. If your Lordships can kindly accommodate that.
No, what is the difficulty in coming to court?
Lordship, presently he's not well. Your
What
Lordship,
is the
for
sufferance?
that reason, Lordship, yesterday we had mentioned the matter.
That's why asking you when can he come?
Physically, Lordship, I have to take instructions. If your Lordship can
Take
verbally
instruction.
May I indicate one thing, subject to your Lordship's kind
Next week you let him come.
subject to your
Lordship, if your
Lordship's kind
Lordship can virtually allow the petitioner to, opposite party to come.
subject to your Lordship's kind leave, my lord. My client is here, my lord. Your Lordship can find him, my lord. He is also with a broken hand. Now, my lord, he has to undergo an operation on 22nd, I am told. 22nd? On 22nd of this month. But thereafter, he is also going to be, my lord, bedridden for some amount of time. So, my lord, entirely subject to your Lordship's, my lord, kind leave, my lord. If your Lordship kindly permits, because the question, my lord, which would, perhaps, my lord, sir, if I may, my lord, make this submission, the questions which would come out is, my lord, whether the settlement has been arrived, my lord, out of, my lord, their free will or not. And what the legal questions, my lord, we are there to assist your Lordship. So if your Lordship kindly permits, my lord, they are also, my lord, agree with my learned friend here.
How long it will take for
him, my lord,
to recover?
He says 2 months.
2 months.
That is the doctor's, my lord, prescription. So if your Lordship kindly permits, my lord, I leave it entirely to your Lordship. If your Lordship kindly permits,
After 2 months,
virtual
it will
appearance,
be pending. When did you file the application?
the application, may I just indicate, my lord, there is a little bit of history here. Lord, 2007, the settlement was arrived at. Entire amount paid. Thereafter, my lord, the matter went in a cold storage. My lord, nobody took any steps in the matter. Finally, my lord, when my lord, a warrant was issued in 2025, my lord, we woke up from our slumber, both of us. Now, my lord, thereafter, this application was filed, my lord, challenging the order of warrant. In the meantime, this criminal revisional application was dismissed for default once. It was restored, restoration filed within time. And my lord, nobody took any steps in view of the fact that the matter had already been settled. So nobody was pressing forward with the matter. So my lord, when the warrant was finally issued, thereafter, my lord, the parties came to their senses that this matter has to be disposed and my lord, set at rest. So Lord, that is when, Lord, despite the settlement being arrived at 2007, the matter is finally coming up before your Lordship and for your Lordship's, Lord, affirmation of the settlement in 2026 today. And Lord, the warrant, the order of warrant, there was an order of stay by this honorable court on the order of warrant. The stay has unfortunately, my lord, now been, Lord, not been extended due to, my lord, Justice Sengupta was taking up the matter at that point of time. So, my lord,
Which is the date?
Date, my lord?
Date on which the stay was granted?
The stay was granted on 10th of July. The date on which it was granted, order to follow. But it was granted, the stay was granted sometime in April, my lord. Thereafter extended.
April
of this year. Thereafter, my lord, I'll just give the date. If your lordship kindly bears with me.
Condone the delay.
May I just give the date? Your lordship kindly bears with me. Kindly, my lord, I'll have to check it is April or not. But the stay was granted. Wait. Shall continue. Stay or it was before June 22. June 22 order is which I find in my hand, where it was not extended till 10th of July at that point, and thereafter, due to the unavailability of the honorable bench, my lord, it could not be extended. 22nd of June 2026, your lordship will kindly find where it was extended.
22nd June. 9th June?
2026, 22nd of June 2026.
Intermediate 10th July.
And my lord, if I may, the
10th July.
Yes. আরে কেন বলছো না দেখে এটাও extension. It was granted sometime in April, towards the end of April, I believe. Lord, 18th of May was the first date of extension of the stay. And thereafter, it was extended from time to time, twice or thrice.
You need to file an application seeking for extension because this has expired.
This has expired. If your lordship desires, Lord, I shall come back with
File an application, give a copy to her, and ask your client to remain present. Since he is also going for an operative measure, he will be after 1 month or 1.5 months. In the meantime, this revision has been filed challenging the judgment.
Yes, challenging the judgment. It was filed, my lord, long back, as your lordship can find, Lord, 2007.
You filed an application seeking for extension of the interim order. In the meantime, let him recover from his
My-
ailment. Thereafter, we'll fix a date for.
As your lordship.
Lordship, only one submission, Lordship. Lordship, the opposite party had the intention to settle. That is the reason, Lordship, we had settled. We had signed in the memorandum of understanding. Now, Lordship, if the opposite party is facing some difficulty, if he can if Lordship can allow the advocate on record to appear on behalf of him, Lordship.
I'm not understanding because you are representing. I mean, allowing you to appear only for the sake of ascertaining whether he has put his signature, what is his intention. Otherwise, you get into the merits of the application and find out what are the grounds. If you are not intended, then we cannot proceed with 3 and 4. 3 is the application for compromise.
4 is the application for
4, 3.
3 is not for stay of the warrant of arrest. That has been now been interim orders have been passed there.
Okay. So you ascertain from your client?
May I make
Yes.
one humble submission? May I make one humble submission here, my lord? Cran 3.
Well, I am appearing already.
Where is your client?
My lord, I had indicated to your lord. My lord, what has happened, I'm telling your lord. My lord, we are, my lord, the victims here. My lord, it is our case.
Yes.
This, I'm telling your lordship, category. But we have secured, there was a conviction which has been granted. Right, my lord? They had preferred a revisional application before this honorable court. That was dismissed for default. My lord, we enter into the picture, my lord, after a service was done upon us. But we went, my lord, to the coordinate bench. But before the coordinate bench, my lord, they show an annexure. They saying that matter has been compromised between the parties. My lord, considering the age-old factor, my lord, of this particular case, my lord, considering for a number of years this case has been going on, my lord, after seeing that annexure, my lord, and we were also, my lord, not properly instructed at that point of time, whether because these were the annexures which were part of the revisional application. But what had fallen from the coordinate bench was that if there is a settlement which they have been annexed, why don't you go for a joint compromise application? I'm fixing it for joint compromise application. Accordingly, my lord, the complainant, my lord, I'm telling your lordship, he is, my lord, a pilot, my lord, due to which, my lord, he has to travel. Now, in spite of that, my lord, because it was a desire, my lord, at that point of time, my lord, we said that very well, we will file a joint compromise application. But in that backdrop, now, my lord, because my lord, we have, it was not, my lord, something which we, my lord, in this present case, that because my lord, they have come up challenging a conviction, my lord, today, my lord, to be very candid, my lord. It was merely, my lord, because it was a desire, my lord, which was being expressed by the coordinate bench, my lord, that we extended this, my lord, support from our end insofar as, my lord, joint compromise application is concerned. But, my lord, insofar as their applicability, my lord, of joint compromise application at the post-conviction stage, and etc., my lord, there are other aspects which are to be, my lord, explored into that. I leave it to your lordships, my lord. But, my lord, this is
No, there are two things.
Lordship.
If on one hand, if the parties arrive at a compromise, orders will be passed. If you are not intending to, then there is no question of CRAN 4, which is a joint compromise petition. Then that has to be dismissed. And we have to decide on the merits of the application.
We have
CAN 3 order has already been passed. To
Not
which
in
we all
CAN 3,
have
CAN
agreed.
4.
No, in CAN 3, my lord, order was passed for filing of this, my lord, CRAN 4.
Main problem, my lord.
To which we all have acquiesced.
That is
May I
why
make one more humble submission, not completely agreeing with my learned friend here.
Because
make one more humble submission, where the parties have appeared before the commissioner while attesting their signature. Putting their signature, they have appeared before the commissioner.
If the court wants, my lord, if the court
wants,
my lord, that's why we are not, my lord, I'm not on that. If your lordship wants, my lord, your lordship can verify, my lord.
They'll have to.
What I'm into is there was a order of stay of the warrant which
not
was
the-
issued
the application
that
is still
was valid till 10th July. I have asked him to take out an application for extension of that. In the meantime, you ask your client, inform this court when he is to appear. Because his client is also have to take a operative measure, has some fracture on his hand. So after 1.5 months, I will fix a date.
I will, my lord, that would be my
In the meantime, let him take out an application.
Very well.
And
We'll
may I also
extend that
briefly point out, my lord, CRAN 3 is not yet disposed of. CRAN 3 is the application on which stay was my lord, sought for. CRAN 3 is still pending before your lordship. So therefore, my lord, if your lordship my lord, kindly pleases to pass an order in CRAN 3 itself for extension of the order, but it may perhaps be passed subject to your lordship's my lord, kind my lord, if it so comments to your lordship. Your lordship kindly takes up CRAN 3 once.
No, my lord is correct, my lord. They have to file an extension application. That
Very
is
well,
the
let
stay
me-
of the
let me,
order.
yes,
No,
yes,
lordship is, my lord, because it is an extension of the interim. Because CAN 3, my lord, was an interim order which they had sought for, my lord.
He's right.
Stay of the operation.
He's right.
You file an
Kindly
application, give a copy to him. I'll list that matter. Ashwin. by order dated 12th August 2026, the parties to the proceedings were directed to remain present since submission was advanced that the parties have compromised by and between themselves. It is placed on record that the parties have also filed a joint compromise petition being CRAN 4 of 2026. An order of stay of the warrant issued by the trial court, learned trial court, is also been passed in CRAN 3 of 2026, which was valid till 10th July 2026. Learned advocate for the petitioner seeks accommodation to take out an application for extension of the interim order. Please, this matter. When can this application be filed?
Lord, in 2 days' time.
Next week, then we'll
Yes,
take it. Under the Indian application, sorry, under the Indian application record.
Deeply amended.
Next week, this will be under heading application. We'll take up that application.
Lordship, only for that application, and then, my lord, the date may be, I will indicate
Yes.
to your lordship on that day, my lord, when they will be proceeded. I'm deeply so grateful to your
Yes,
lordship, my lord. Much grateful to your lordship.
Two. Who is for the state? State who is appearing? You are for, you are not, kindly take the microphone.
No,
You are,
email has been reflected in the cost item, my lord, so, cost list, my lord, so press service needs to be effective.
you are for the petitioner,
I'm for the state. I generally appear for the state, my lord.
but then petitioner was directed to serve a notice. That notice has been served.
I've not received it.
None appears on behalf of the petitioner. Miss So-and-so learned advocate appears for the state. For ends of justice, the matter is adjourned. With this matter on 2 weeks for now. They have filed a written instruction that the petitioner does not intend to proceed further. But since the petition is not there, I'm placing it after 2 weeks. Let them come. Under the same heading, go. We mentioned it. আজকে হবে না মানে সীমা সিং কবে আছে এরা দাও এটা তো শুনছিলাম
Mr. Souvik Mittal is appearing this matter due to some personal difficulties not present today.
Who?
Souvik Mittal.
My lords,
Can you appearing in this matter, Your Lordship?
we have just recently found out that the application what they filed in Supreme Court, they had suppressed lot of facts. So should I have given additional supplementary in that to file that application, Your Lordship?
Not right now. The other side is not here. Why this was
Lordship,
not
that is-
indicated by Mr. Francis?
Pardon, Your Lordship.
On the date the matter was heard on behalf of the petitioner, he did not indicate that.
Right, because we did not, when we got this, Your Lordship,
This is in 2012, sir.
We were not then the advocates, Your Lordship, that time. Subsequently, we have come into into this case. The fact, Your Lordship, in this what we have seen, after they have said, if you see the Lordship, the order on page 37 of the Supreme Court, they had said to, in the second page, Your Lordship, that within a period of 4 months, 10,000 should be given within 4 weeks. Now, so many days have passed, they have not paid any 10,000 till now. Subsequently, when we went through the petition, Your Lordship, which they filed in Supreme Court, we have seen that the subject matter of CRR 3714 of 2012 has not been mentioned. A direction was given for Hooghly Court, 5th GM, to hear the matter. Order was passed. That also has not been reflected in the Supreme Court application.
But the order of the Honorable Supreme Court records of the CRR number?
About after that, Your Honor, when the thing was allowed for hearing, then at the 5th GM Hooghly already decided the quantum of money amount. That has not been mentioned in the petition. That was case number 250 of 2007, where 5,000 direction was given. And that is given in our supplementary, page number 17 and 21, we have given that. But in the Supreme Court application, they said they did not receive any notice. But we have a document showing that the uncle or grandfather has received the notice. So these things they have not taken up there. So an order, if it been passed by a fraud, it's not an order. I should not say that, but even the address of his, Your Lordship, we have come to know from a consumer forum case that his name is there and his address is given there, which he denied. In one of his affidavits, he's writing that I'm unemployed. In the other affidavit, he's writing, Your Lordship, that he's doing business.
These matters, if we file a supplementary affidavit, again, they will be coming up with an opposition.
I know it's a delay of time, but if Your Lordship permits me, on that day, I'll give them a copy of the application, if you permit me. I don't want to delay it because it's so late already.
Accommodation is sought for on behalf of Mr. Souvik Mittal, learned senior advocate appearing for opposite party number 1. কবে দেবো? দশ দিন বাদে দিন next 2nd September.
Let the payment be done, Your Lordship, because the payment is
No,
not
I was
specified.
hearing this is at the final stage of hearing. Now you have indicated that there is certain facts which has not been
Your
stated
Lordship, my
before the
junior
Honorable
was
Supreme Court.
submitting. I didn't want to intrude, Your Lordship.
As per the submissions advanced by the petitioner, he has also argued on some points.
Right, Your Lordship.
But
But at least the payment of 9 lakhs is still due. As you say, as previous as you say.
On that day, if you intend to file any supplementary affidavit, let the other side come.
No, I give them a copy of the Lordship permits me, then I'll file it before the court. I have no problem. It's just to indicate where the mistake, or I would not say mistake, of fraud has been taken. It's nothing else.
Okay.
Much. Same position, Your Lordship. Much.
Same heading, same heading.